We can start. Good morning, everyone. Welcome to ceipi. Welcome to this conference dedicated to the first year of the UPC. Welcome to the participants who are here in Strasbourg, in Cardo, our building. And welcome also to the participants who will follow us online today. It's a real pleasure to be able to welcome you here today to talk about the UPC, and in more ways than one. This conference is first and foremost an opportunity to recall ceipi's resources and its ability to organize high-level training courses and conferences in all areas of IP. This versatility, which is one of the ceipi's strengths, is due to its team, which includes specialists in copyright law, trademark law, artificial intelligence, and of course, patent law. We owe this conference to two men. Stéphane Martin, members of the UIPO's Board of Appeal and chairman of the CPVO's Board of Appeal, who, for those who know him, masters all the subjects. And Andreas Dilg, our new director of the international section. It is important to point out that he has been director of this section since 1st of July. 3 months later, he became scientific director of a major ceipi conference. I would like to take this opportunity to thank them for organizing this conference. I would like also to thank Stephanie Strasser, who managed all the logistical and administrative aspects of this conference. And I would like also to thank all the financial support, the sponsor, eBrand, Fovea, LexisNexis, Papers IP, Questel, and DHS. This conference also serves as a reminder that patent law, and more specifically the UPC, is at the heart of our concerns. As you know, for more than 20 years now, ceipi has offered a university diploma related to patent litigation in Europe, with 4 modules on the UPC. The university diploma for patent engineers also includes lectures on the UPC. I would like also to remind you that in October 2022, ceipi organized a major training course for technically qualified judges of the UPC after being selected by the preparatory committee of the UPC. Today, this conference confirms our determination to invest fully this area, and I hope that the future will enable us to strengthen our position on the subject. Lastly, this conference is of course an opportunity to make a review of the first year of the UPC. As we know, this is a unique court, which was particularly eagerly awaited by practitioners. This expectation was sometimes accompanied by a certain perplexity, even in skepticism, or even a certain fear of the part of some. Today will be an opportunity to see that these fears were perhaps unfounded. We are uniquely fortunate to have speakers of such high quality from a wide range of backgrounds: judges, academics, patent attorneys, and lawyers. I would like to thank you all for agreeing to come to Strasbourg to share your experiences and expertise so that we can make this first assessment. I would particularly like to thank Florence Butin, President of the Court of First Instance of the UPC, for taking the time to speak us today. To conclude, and I would like to make some advertisement for ceipi, I would like to remind you that 2024 is an important year for ceipi. On 15 and 16 October, we will be celebrating our 60th anniversary at the European Parliament and at the Palais Universitaire. There are still a few days left to register to come and celebrate this event with us. So I have already said too much. I hope you have a wonderful day and a wonderful conference. Thanks a lot.
Ladies and gentlemen, I would also like to cordially welcome you to our seminar, 1 year UPC, the first year in review. And in addition to the thanks of Jan, I would also like to thank you as our General Director for giving us the opportunity here to have this interesting seminar. And of course, to all of the speakers, all of you are very busy in your professional life, and we really appreciate that you took the time to come to Strasbourg and have prepared your presentations, and we are really very interested in what you will explain us about the first year. Yeah, what does the UPC and ceipi have in common? Both celebrate an important anniversary this year. For ceipi, it's the 60th anniversary. For the UPC, it's the first anniversary. But I would like to say that on the occasion of this birthday party today for the UPC, I personally am very impressed how adult the UPC has become within only 1 year, which I, frankly speaking, would never have expected in 2023. So I think that's a story of success, and we all hope that it continues, and we will see different aspects of the UPC presented by the different speakers today. So, since we have a tough program, I would now like to give the floor to our first speaker, Mrs. Florence Beutin. Florence graduated in civil law and served in the French judiciary system for 25 years. She also joined the Paris Court of First Instance in 2012, later then also in the Intellectual Property Chamber. And in 2022, Florence took office as president of the Court of First Instance of the Unified Patent Court.
Thank you very much. The only problem I may have is the coordination, because I have my notes here on my computer, and then I will have to manage to follow what is displayed. And also, sorry in advance if there is some changes. So thank you very much for inviting me, first of all, and apologize in advance, because when I received the letter of inviting me in this event, it was said in this letter, you can talk about what you wish. And then when I received the program, it was something in particular to address, which was the organization of the Unified Patent Court as such. So I thought that I can make a sort of mix, talk about general aspect of the activity of the first year, and then later on something more in details regarding one important aspect of the functioning of the court, which is the use of the bifurcation process. So let's start with the free location of the central division. So you can see the different sections: Paris, Munich, and Milan. Yes, regarding the content of this presentation, so I do hope it will meet your expectation, because yes, I try to make a sort of mix. I will start with the distribution of cases, which is an important aspect of the functioning of the court. So as you can see, there are some divisions receiving more cases, and it's a process in progress, and then we can imagine that in the future this distribution may be different, but at the moment you can see that the most busy division, or the Paris Central Division, so which is linked with the EPC class, and then it may also change with the implementation of the section of Milan, and the Munich local division, which is clearly more busy than the others. So it's the current situation. If I can make a brief comment about the category and proportion of actions lodged. At the moment, there are almost 200 infringement actions that I disregard the counterclaim for revocation. I will talk about that later, but a particular aspect of the UPC is that you distinguish two different kinds of actions, the infringement and the counterclaim for revocation, which is considered as to some extent an action as such, which has consequences in the functioning of the court. The revocation actions reach 45 at the moment, with 2 counterclaims for infringement, and almost 40 provisional measures, and 8 applications for preserving evidence, and 2 orders for inspection, which means that even if the court is supposed to be quick regarding the decisions on the merit, it remains interesting for the user, obviously, to make use of the provisional measures to be granted in this context. As will. So this is the same, so I go quickly on that. Let's talk about the classes in the patent in suit, the most frequently seen classes. So we immediately see that the class H is quite an important proportion of the patents in suit. And it's the same for a bit less, but still important proportion of class A in both type of actions, both infringement and revocation. This has an impact on the designation of the technically qualified judge in the panel. So probably we will have the opportunity to address this point later. As regard language of the proceedings, so it will deserve a whole conference, I think, this topic, but I will address that briefly. At the moment, we have in the total proceedings, so you can see the proportion on this slide. So it is 53% of English, but if we consider only the infringement cases, the proportion of cases in English are 45% against in German 49. So which means that the German language is still importantly used in the court, with of course consequences regarding the composition of the panel, because to the most possible extent, of course, we consider that all the judges of the panel have to manage to understand and to read the submissions. About the language change request, as you know, according to the rules of procedure and agreement, it's possible to ask for some a change of the language with regard to the language of the patent. And this possibility was used because 19 language change requests have been filed so far, and followed by 2 agreements before the request being sent to the president of the court of first instance, because it is for the president of the court of first instance to decide on this request to change the language of the case. The change was refused in 11 cases, and the change was granted in 6 cases, so which means that it really depends on the particular situation, which is normal because it's for grounds of fairness. So which means that it's really an assessment with regard to the particulars of the case, and the Court of Appeal ruled on that. As you may know, there were already, if I'm not wrong, 4 decisions of the Court of Appeal in that respect, and the first one decided to grant the change which was not granted at the first level, and the second decision was to confirm the decision taken at the first stage, and the 2 latest decision was to decide to change into English while the change was not granted at the first stage. So it's at the moment the situation with regard to the appeal on that point. So this is, and then I would like to kindly ask you to be careful, because this is really a homemade tool for this assessment of trending case filings over time. But even if it's not completely accurate, because it depends on all the cases we enter in a specific file to try to obtain this. These statistics, which for these reasons is not published on the website of the court, because it needs to be further elaborated to have a very accurate picture of the situation. So, but still, we can see in the June, July, and August that there is already a possible comparison between 22 cases lodged in June 23 and 31 cases filed in June 24. I don't talk about August, but I think it was a bit a particular situation compared to last year. But it was 4 cases lodged in August 23 and 24 cases lodged in August 24. But I think it's probably because the users users were much more organized and in their capacity of filing cases during this period. I explained that way. September 23, the court received 16 cases, and it's September 24 to date. So I mean. Until now, it was 22, so it allows also comparison. My interpretation is that yes, the users tend to trust the court as it is more used than last year. So it's we will see with the time, because we will be in a transitional period while some cases will be closed, and so we will receive new cases, and we will see where it is balanced and how it works for the next time. If I continue with my personal summary of the main insight for this first year, where for the court the determination of workload per judges and adjustment for the working capacity, because as you know, the UPC is a particular organization in that respect, because the judges, most of them still are in parallel employed by their national court, and which means that it's very important for the HR, the management to be able to assess the number of cases that a judge can take, and also it has an impact on the composition of the panel, because the functioning of the court is that you have there's different locations, so different divisions of one judge and two judges, and for each case, each single case, there is a decision allocating a third international judge. So it means that for each case there is a specific decision ruling deciding on the composition of the panel, which is taken, of course, with regard to the distribution of the workload within the court. Another interesting aspect is the standing judge scheme, because the standing judge is like at the national level you have a judge specifically designated for very urgent actions, so which means that the court shall provide for each very urgent action, whatever the language it be. It can be Danish, it can be German, it can be French, it can be Portuguese in theory, and then it can be any language, and then the court shall provide a judge likely to deal with this request very quickly. So it's also something very particular in the organization. Another interesting aspect is the involvement of the technically qualified judge. It's another very important feature of the court. When this judge is involved, and where there is a specific presentation on this point, I think so. I will not be very long on that. I will just mention that the court, during the first year, as it has been mentioned just before my presentation, the size of the court already changed within the first year of activity, because we started with 30 legally qualified judges, and we are now 35. We started with 50 technically qualified judges employed at first, and then these technically qualified judges are 75. So it's an important increase of this pool of technically qualified judges. And the percentage of working time of certain judges of the court also was increased by decision of the Presidium with regard to the workload of the court. So it is the main aspect of the evolution. If I had to summarize very briefly the situation of this first year, I don't talk about the conflict check, because I know that this point will be addressed later. by my colleague this afternoon. So I go to my second point, more in details regarding one aspect of the functioning of the court, which is bifurcation. There were a lot of articles about bifurcation before we started, and there we were interested to know how it works in practice. So I will very briefly recall the legal provisions about that. As you probably already know, that there are different options for the panel dealing with a case. So to proceed with both actions, meaning infringement and revocation, counterclaim for revocation, to refer the counterclaim only and suspend or not the proceeding regarding infringement action, or to refer the whole case if the party agree on that. So it is translated in the rules of procedure. So it is more in details indicated in the rules of procedure at which point of time this decision can be taken, and the fact that the parties have to be given an opportunity to be heard, and the panel can take an earlier decision if it's appropriate. So this is the rules, and we have already an important number of decisions on bifurcation. The first one I have found for the purpose of this presentation, and maybe there is more decision that I don't mention, but I took some decision allowing the bifurcation or not allowing the bifurcation for just to compare the grounds. So in this decision, there was a reasoning on the time frame. So the decision can be taken before the closure of the written procedure. And finally, even if the rules present as the normal time frame that the decision is taken immediately after the closure of the written procedure, we see with the case law that this decision is generally taken before the closure of the written procedure, because for different reasons, which are mentioned the same way in almost all the decisions. So and specifically the early assignment of the technically qualified judge is advantageous for the court, because as the TQG is added to the panel in principle where the counterclaim is lodged, it means that the technically qualified judge can join the panel earlier than planned by the rules. The aim of efficiency is generally mentioned, and also, of course, the uniform interpretation of the patent for both actions when the local or regional division is dealing with the whole case. So it was one of the first, if not the first, decision about bifurcation. Another one is exactly mentioning the same reasoning as regard the time frame, the aim of efficiency as well by the early involvement of the whole panel, and the fact that no objections was raised by the parties about such early option. I think that it just in brackets, but we can see in the case law that in general, the opinion of the party is largely taken into consideration by the decision. It is mentioned whether the parties tend to agree, tend to not to agree, and it's an aspect of the reasoning to take the decision about the bifurcation. Another decision is still the same regarding the time frame. So you can already see a certain consistency in the content of the decision of the Unified Patent Court. I just mentioned that because in some comments you could have questioning about how the UPC will be able to function with so many different locations, so many different judges with different backgrounds, cultures, and how the decision and the case law can be harmonized. So in this particular aspect, of course, it's a specific point because it's really yes, a basis of the functioning of the court, but still I think it's reflecting the situation and how it can be harmonized. Yes, it is also mentioned in this decision that it is advantageous to decide also on infringement aspect of the case with a technically qualified judge, which was a question we had at the very starting point of the court, whether the TQG would be involved or not so much involved in the whole case. And then it appears with the practice that the TQG is really involved in the whole case as part of the panel, like the legally qualified judges. Another decision is this time taken by the local division The Hague, who decided to not bifurcate and decided that before the end of the written procedure for the same reason, and mentioning also that it was the preferred option according to the parties. I am wondering when I arrive at the point where the bifurcation is decided, because now we have a decision from Mannheim taken also before the closure of the written procedure, and mentioning, so usually in the decision it is recalled that there is a discretion in taking this decision to hear both actions together or not. It's the decision of the panel, depending on the particular aspect of the case. And then it is said that the no is missing, but it is mentioned that there is no, in this case, particular aspect that could call against the option to hear both cases together. And it is also mentioned, compared to the other decision, it's an additional point which is mentioned, which is the current situation of the court, which is at the moment still on a starting phase. Another situation where the bifurcation was not decided, it was here mentioned, it is a decision from Munich, recalling the main rules and saying that there is no agreement for a referral of the whole case according to the parties, and an agreement of the parties that both actions must be heard together. So, and the court decided to handle the case accordingly. This decision is not adding something more compared to the other decisions, so I'm going to continue. And there is one which is a bit different because in this particular case, there were two situations addressed in parallel by the panel: the bifurcation and the stay. And in this case, the particular situation was that there was a parallel revocation action, which is I would not say frequent, but yes, in some situations there is parallel proceedings, infringement proceedings, and revocation proceedings. And in this case, of course, the question of bifurcation is may be handled differently with different criteria in this case. And in this situation, the panel, even if there was a parallel action, decided to hear both actions and said that the claimant's interest was to continue the proceeding and so to continue the infringement and the counterclaim for revocation, and not decide to stay regarding the infringement action. I just mentioned in this situation that because it's an interesting example, the court is always has to decide whether the panel can be identical. Not all the judges identical, of course, but one of the judges can be the same in the different panel for the revocation and for the infringement. It's the situation. It's the same situation for the TQG and for the LQG. And in this case, the technically qualified judge was assigned first in the revocation action, because in the revocation action, the technically qualified judge is automatically added to the panel. And for the infringement, after the counterclaim for revocation, the question for the court was whether we allocate the same technically qualified judge to the other panel. But the first case was of course in English, and the second case was in German. And finally, and the technically qualified judge was Italian, like to handle the case in English, of course, like all the judges of the court, but not so easily in German. And finally, there was a request for changing the language, and the language in this case was changed. Mais pas pour l'audience, si.
Si en ligne ils n'arrivaient pas. Et donc là normalement c'est bon.
Je continue ou pas?
Oui, normalement c'est tout. Merci.
Okay. Merci. So I go into a situation where the bifurcation was decided, and still in all the cases where the bifurcation was decided, it was because there was a parallel revocation case before the central division concerned. And in this case, it is mentioned still the same rule, but it is usually advantageous to hear both cases, and which was taken into consideration for deciding to bifurcate was the date of the central division oral hearings, but the fact that there was no particular reason to stay at this stage because there was not a strong likelihood of revocation, so it is in line with the rules. So it is one of the situations where the bifurcation was decided. In Mannheim, it was also decided in favor of the Central Division Paris, saying that it is generally appropriate for local division to hear and decide on the whole case, but here there was almost the same attacks raised in both actions, so you can have different situations, of course. In some cases, there are different reasons to challenge the validity of the patent, and yes, if the arguments are almost or more the same, it can be interesting to decide on both action. The efficiency was mentioned and the procedural economy was mentioned, and there were, in this particular case, a number of arguments raised by the parties, and especially with regard to the language of the case, and it was mentioned by the panel, but it was not so detrimental for the parties to have this change, and also the time frame of both proceedings. That it was also mentioned by the panel that finally, even if the proceedings are at a different stage, they can be heard together once they are the two cases are ready to be heard. So these arguments was considered as not valid sufficiently to not bifurcate. So I will just mention, but more briefly, because it's linked with the first topic. The rule 340 is another tool for the UPC to avoid inconsistent decision, which means that when cases concern the same patent, they can be these two cases can be heard together by application of this rule, and there were some questions about the application of this rule. If we summarize the case law about that, it was addressed at first in the Paris Central Division, so it says the 5 minutes, so I finish very quickly if I can. So three additional slides. And in this case, the request was dismissed first because it was not timely lodged, and as a second aspect, there was another decision mentioning that I think for the first time that it cannot be derogated by the use of this rule. It cannot be derogated to the agreement regarding the competence of the respective division, central and local division. In another decision taken by the local division Mannheim, this article, the UCPA 33 prevails over Rule 340, and so it was another time that it was specifically mentioned, and. Here, which is interesting, that there were a question about interpretation of this rule, whether how it is handled with a joint panel. Is it a joinder, as we know, at the national level? And then we can immediately see that in the court UPC frame, we always have the question whether the procedural tools shall be interpreted in light of what we already know, what we are used to in our national frame, and so sometimes it's different because, of course, the context is different. It has been ruled on that by the Court of Appeal. So, and the Court of Appeal clearly mentioned that the Article 33 cannot be disregarded by the use of the Rule 340, and so it cannot. With this rule, the panel cannot go beyond the possibilities provided for referral of actions. So it has been clarified by the Court of Appeal. So what we can very briefly conclude on that is that finally we had an idea of the bifurcation as something that likely to slow down the proceedings and that can be make the functioning of the court complicated and question the efficiency. And finally, this situation is slightly different, meaning that bifurcation is used when it is really relevant to use it at least according to the view of the panel for the handling of the case, and which is all the time mentioned by the decision, but completely in line with the rules of procedure, which are to avoid different diverging decisions and for the efficiency reasons and to handle the case the most efficient way as possible. So that is the practice. I just would like to thank you very much for your attention, and then I will be happy to attend the rest of the conference, even if I will be able to interrupt myself and do something else. I don't exclude to raise my hand sometimes if I am interested to say something. Thank you very much. Sorry. Another point that I wanted to address is, of course, my role is a bit different in the court, because at the moment I have very few judicial activities, so I'm limiting. So at least I hope it's the impression given. I don't take any opinion about the decision. I just describe the state of play, and it is the judges themselves are much more aware of the reason they take the decision. I just, for this purpose, I try to give an overview of when the bifurcation is granted and when it's not, and sometimes the bifurcation is not decided, but there is no specific decision on that. It is considered that it is normal functioning of the court to handle the whole case together within the panel of the local and regional division. So it is the disclaimer from my side. It's just a description of the case law at the moment. Thank you.
Thank you very much for this very interesting overview. I think we have maybe time for maybe time for one or two questions, if there are any. Yes.
In the case Stroma versus Revolt, the preliminary injunction was not decided by a technical judge. Why not? If later they decided they needed the technical judge.
So I just repeat the question because we didn't have a microphone here for the people online. In one of the cases, a decision has been taken without technically qualified judge.
Preliminary injunction.
In a preliminary injunction case, are there any reasons for that, to your knowledge?
Reason for that, I don't, because at the president level, so the president office, when there is a request for a technically qualified judge, the office receives the request and allocate the judge. I can just mention on this point. It can be many different reasons, but what I can say that it's usually we could note that even if it is not expressly provided by the rules of procedure, it is true that finally it is quite frequent that a technically qualified judge is involved in the infringement actions. And even in provisional measures, and sometimes it is the case, and sometimes not. I have not example. I don't have example in mind, but I think it's not only in this case. It could be in other cases. It depends. It can be the urgency. It can be many reasons. But I think that it's really an assessment on a case-by-case basis, and I would insist on one point: the parties have the possibility to ask for it also, and in this case, the panel and the panel also take the initiative. So I cannot respond this question very. It's not obvious. It depends on the case.
Thank you very much. We have one question or comment from Mr. Dr.
It's an answer to the question, because on the instant facts of that case, I'm the presiding judge of the Mannheim local division. It was an ex parte PI, so there was an ongoing trade fair, and they wanted to clear the booth of the trade fair within 2 days. And therefore, it was just not possible to get someone on board. It was really just that the trade fair ended the next day, and they wanted to clear the booth. And therefore, for the reasons of time constraint, it was not possible to get a TQJ on board.
And we will talk about that later, but the conflict check process can take some time and can be done very quickly. It really also completely depends on the situation.
Thanks a lot. We have one online question, maybe, finally.
Yes, we have actually two, but very quick questions. The first one is, were there any remote hearing, and if so, in what proportion?
I am not... on the merit, you mean?
Yes.
Hearings on the merit? I don't think that so far there were hearings on the merit. The principle is the hearing on site, and even for there were also some hearings on site for not for the hearings on the merit. So what is privileged in principle, depending on the situation, of course, but to have the hearings on site. Peter, you have an idea? I think there were so far there were no remote hearings on the merit. No, and so on.
Well, we had a case where in the interims conference, the court gave some comments on the merits of the case, but they were not expecting the parties to comment on it.
We have here a second question from the audience online. There is a question regarding the allocation of case between the local division. The person is referring to the fact that it's quite uneven, with 70% of the cases are based in Germany, while some divisions have only a few cases. And the person is asking if it is of concern, and if yes, what could be done to change that allocations.
I think it's not so easy to change the agreement. I think it's we should not so quickly conclude, as it is still the start, not really the starting period, but this is in it's a movement, and then at the very starting point there were more or less the same situation, but with the time, some division receive more cases, and I think it's also reflecting the situation at the national level. Because, for example, in France, you have one court dealing with patent, and in Germany you have several courts dealing with patent, and then automatically it has an impact on the cases. And so, as we started from national frames and we come to an international court, and I think it may take some time to have this international court, but of course the aim is, I think, but it's a personal point of view, I think the court shall be work in such a way that the users, when they go for convenience to one location compared to another one, they would consider that as a main aim to go to the UPC, but not go to Munich or Paris. But yes, it's a process that takes, I think, some time. But it would be interesting to ask this question to the users as well.
Thank you very much.
So we will talk about procedural aspects of the UPC and give a first insight on the case law within this a bit more than first year. We have structured our presentation in 7 parts. We could do much more, but time is limited, so we're absolutely not exhaustive on any of the aspects that were already handled by the court. We will talk about languages, case and claim amendments, time limits, confidentiality, costs, very important, but also of preservation of evidence. And so let's start right away, Konstantin, with the language issues.
Yeah, thank you very much. Thank you very much for having invited me. May I take the opportunity to comment also on the last question, because it is a question that is very important, the question of could it be a problem that 70% of the cases are in Germany and before the local and central division there. My personal view is that it could be a problem on the long run, and the court should also look at the reasons on why this situation happened. There are different ways of the judges behaving towards the attorneys at law, the patent prosecutors, but also to the clients of the court. And I personally think, for example, I have some experience also with the French panels, and I think the quality in France is very high. And I can only invite judges from the divisions that have less cases now than the German divisions to be self-confident and to make some effort in order to be seen as broadly as the German divisions are, because they are not better. There are simply more cases there, and it would be a great goal, a great aim if, as you said, in some years we would have a balanced level of cases in between the local divisions. But this is only a comment because it's I thought a lot about it, and I think it is important for a European project to be a European project and not a 60+% German project. And it shouldn't be seen as this from outside Europe either. So this was my first comment that was not really what I should say. Now I will say something what I shouldn't say either, because I'm dealing with language issues, and after Madame Butin, it is difficult to talk about languages, because in essence it's her caseload and her decisions, and then the decisions of the Court of Appeal. But nevertheless, I will try to give some insights. The general principle is, we might remind it, or the general rule is in the agreement that the local divisions hear the case in the national language of this local division, and then the countries, the contracting member states can decide to have another language of the European Patent Organization, which means French, English, and German, to be a possible language of the proceedings. And only a few days before June 1st, 2023, almost all local divisions decided to have English as a second language. And we have now the possibility that, for example, in Germany, you can bring the cases in German and English. And with the Paris local division, you can bring the cases in French and in English. There is no local division left where it is not possible to bring a case in English. And this is the door opener for the discussion under Article 49.5. For Article 49.5 says that for grounds of fairness and taking into account all aspects and especially the interests of the defendant, which is an important role, the language could be changed into the language of the patent in which the patent was granted. And you all know that almost 70% of European patents are granted in English. So the question is mainly should the case stay in French or in German, or should it be switched to English? There was so far no discussion where the court case started in English based on a patent written and granted in German. So the general principle, as I said, is the language change if amongst all relevant circumstances to be considered, the language initially chosen is significantly detrimental to the other party, which translates also into that if you have a balance of interests, then the interests of the defendant shall prevail. We had several decisions where the language has been changed. Madame Butin gave you the figures. I just cited two of them from the local division Düsseldorf because they were one amongst the first ones. But I mean, it's cases before the local division, but as you understood, it's Madame Butin with the competence that she has from Article 49.5 who decides actually. So the panel refers this question to the President of the Court of First Instance, and then the President decides. In Arke versus SodaStream, we have an Israeli-based company, SodaStream, against SME based in Sweden. The patent is in English. The working language of SodaStream is English, and the court case was brought in German. And the defendant said that it is detrimental for them to bring this case or to defend themselves in German because they have no contacts to German lawyers, German patent attorneys, and it would be difficult for them to translate everything. There at the beginning it was a question if the nationality of the judges and their language skills could play a role, but this is no question anymore. The judges by definition have to speak English, and therefore one could not say, but this judge speaks a bit less well English. It's not a discussion anymore. The interests of the parties prevail and not the interests of the court. In this case, the language was changed. Also, the language was changed in Samsung versus Headwater Research. It was simply no inconvenience for Headwater to use English, but it would have been inconvenient for Samsung to use German. This is, of course, something where you could have some doubts because these big tech companies, they, as you could see if you look at their track record before the German patent courts in the last 20 years, they can organize having cases in German, but nevertheless it is easier for them, of course, to have it in their working language. And since there was no particular reason for Headwater to have it in English, it had to be changed. Two changes have not been granted. The first one was Seoul versus Laser Components. Laser Components is a small company based in France. Working language is French. And Seoul Vuses brought this case in French. And the reason why laser components wanted to have the language changed is simply that they didn't really feel reliable or for the patent infringement, because they wanted the supplier of the products to be in the case. This brought some other problems we will not discuss here. But in the local division Paris, or Madame Butin decided that it was a respectful way of treating the defendant to bring this case in French against a small French company, and it's the interest of the parties that shall prevail and not the interest of a third party intervener. And a similar situation in Advanced Bionics versus Med-El, Elektromedizinische Geräte. You talked about this, Madame Butin, in a different context. There were parallel proceedings and revocation actions, but they are not relevant. And this is, of course, logical, because the revocation proceedings have to be brought into the language in which the patent was granted. So this could not be. There's no choice, and this could not be a good argument. And the president of first instance pointed out that there were 2 defendants out of 3 that were based in Germany and Switzerland, German-speaking part of Switzerland, and the plaintiff itself was based in Austria, so there was no reason to change the language. Now, this did not move to the next slide.
No.
Yeah. Okay. The Court of Appeal stated in 2 cases. The second one is, as you said, Madame Butin, it's actually 2 cases because they were heard together. But in the 2 decisions that I cited to you, they clarified a bit the jurisprudence, reminding that the competence or the initial competence stays within the hands of the president of the court of first instance, and there's only a control if there are aspects of utmost importance that give need to change, to amend and to alter the first instance decision. They reminded the general principles. All relevant circumstances should be related to the specific case and the position of the parties, and in particular, as it is stated in the agreement, the position of the defendant. And then they cite 4 circumstances of particular relevance, which are the language that are most used in the field of the technology involved. Also the language of the evidence, including prior art. If you have a patent in English and 20 documents all in English, then there might be a reason to hear the case in English. Of course, the nationality or domicile of the parties. I don't see a possibility for, let's take a small and medium-sized French company suing before the local division Paris in France based on an English patent. It would be very difficult to change, in this case, the language into English. And also the parties' relative size to each other. And the latest decision from the Court of Appeal added some relevant circumstances, namely the internal working language of the parties and the possibility of internal coordination and of support on technical issues. They are also relevant in these cases.
So then let's go on to questions of how or in which cases can the case be amended. First, looking into revocation proceedings, late filed prior art. Is this admissible or not? According to the agreement, it's up to the discretion of the court. And here in the Fellows of Harvard College versus Nanostring case, there was a document D46 filed in response to the rebuttal of the revocation action, and here it was decided that it was admitted into the revocation action because it was a clear response to something brought forward by the patentee. But the patentee must be given the opportunity to respond to this new document, and in this case they were granted a 6 weeks time limit starting at the date of the interim conference. There's also the question in an infringement action of whether you can add a further patent into your action. And here in the case of Netgear versus Huawei, the claimant brought a new patent into the proceedings because this patent at the time of filing of the infringement action was in limitation proceedings before the EPO, and at the time of the filing of the infringement action they had no certitude about what was the scope of the patent claim, so they could not assert anything on that basis, and the court considered this and said that's true. This must be admitted into the proceedings now, but the defendant must have the same time limit to respond to this new patent as if it was a new action, that is 3 months. And in appeal, the Court of Appeal stated that the time limit of the 3 months runs from the date of 18th of January, that is the decision of the review panel, and not the interim conference, because the statement of the judge rapporteur was not sufficiently clear of the starting date, so they moved it to the decision of the review panel. Admitting this into the proceedings, I think, Madame Boutin, you would agree, gives some problems with the calendar. Adding 3 months into a running proceedings is quite complicated, and what was proposed here is like taking out this as a separate action and letting run a complete new workflow to keep the old time limits and have new time limits for this case. So it's more or less now as if it was a separate infringement action filed later. And there's also the case, what happens if one surrenders part of the action. We had this in Dolby versus HP, where Dolby at one point saw that there were in the products, infringing products, components of one of their own providers, and so said, okay, we won't go after those products, but the rest we'll still go after, but a certain type of products is not part anymore of our infringement actions, even if they are sold by the alleged infringer. And there the court said this is always admissible within the meaning of Rule 263(3), because it's an unconditional limitation of the action, and this is always admissible without any discussion. And speaking of about amendments in infringement in revocation actions, of course, we have auxiliary requests. They are not handled under Rule 263, but under Rule 32, which states that any subsequent request to amend the patent may only be admitted into the proceedings with the permission of the court. And so now we have the first decisions on when we might expect permission or not. A first question is, can you just amend the claims out of your own volition? And there it's a clear no if it's directed to unchallenged claims. And here we may note that that's a difference with EPO decisions practice, because before the EPO, claim amendments are allowed if they pertain to a ground for opposition under Article 100, even if it's not invoked by the opposing party. Here, we need a challenged claim to amend it. We cannot remedy problems we see as a patentee before it's invoked. And then there's the question of Articles 84 and 123.2, clarity and extension of matter. If auxiliary requests are not accompanied by any explanation as to those two articles, they're inadmissible, and then any further request is also inadmissible. However, if there is some explanation but it is not sufficient, then it's admissible but unfounded, and further requests to remedy or this or some problems, they will be admissible. And I think what is very interesting to practitioners is how many auxiliary requests may one file. It's a lawyer's response. It depends. As always, as also before the EPO, there's no hard rule on it's 1, 5, or 100. It really depends, and we have a first decision that says one point to be taken into account is the number of nullity attacks. In the case, I think we had about 8 different nullity attacks, which had to be addressed, whether one works or the other works. It gives different limitations, and in the end, it was like 9 different limitations, which then were combined, amended, and we ended up with 84 auxiliary requests, and that was deemed reasonable in that case. So I think it's quite in line with the EPO practice here for the time being. And perhaps a small word about extension of time limits. Coming from France, I think French practitioners are quite used to extension of time limits in court proceedings. It's been quite clear since the beginning, or even before the start of the UPC, that the approach is very different, that extension of time limits are very exceptional, and the standard is you have to do an evidence-based demonstration of the impossibility or real difficulty to respect the time limit. And I just want to give some examples when time limits were extended and not. For example, we can cite a case where the counterclaim for revocation and the application to amend the patent claims must be filed within 2 months of service of the statement of defense. That's true. But no, sorry, I got something mixed up. Yeah, it was the case where it was not very clear to the defendant when the time limit had to start. And then we got a clarification, and the time limit restarted. They got a small extension because the justification in the first case was not sufficiently clear for the defendant to know which exact date it was, whether it was the service or the update of the workflow on the CMS. And so they got the time extension of the difference between the two. I think now it's clear to everyone, and that won't be reproduced a second time. I think one very well justified case of time extension is the action that was not served with the attachments. So the defendant could not position themselves on the merits of the case because they only had the action itself but not the evidence on which it was based. There was also a question in a friend-related case where it was stated time extension is only to the part of the friend question with the redacted documents, not to the whole case. So it's only a small portion where you can have the time limit extension. For the rest, you have to respect. It was also, there's also a case from Düsseldorf where it was said you can have an extension for the confidentiality regime. We will hear about that a bit more later on. And the local division in Hamburg, in a similar case, stated or clarified that the start for the time limit is the conclusion of the confidentiality proceedings, and you can't start before, because if you don't have knowledge of what you're supposed to know, you cannot respond. So it's postponed until you get a decision on the Rule 262A proceedings. But there's also cases in which the extensions were denied. For example, language change, we talked about that before. In this case, it was considered that the language change, even 1 month before the time limit of filing the statement of defense, was not a reason to extend the time limit, but there also you have to consider the case as such, because the defendant is an international company located outside Europe. Working language is English. The attorneys filed the case in German, and here the court said, in any case, in order to communicate with your client, you already had to translate everything into English, and you have everything in English, so change of language doesn't add any burden on you. There's also an interesting case in which extension of time limit was denied. More or less, there was a small hiccup with sending or uploading the supporting attachments to the case, but it was eventually done. But the representative did not open the attachments in time, and so it was ruled that negligence is absolutely no reason to obtain an extension of time. And also is not coordination with suppliers, but here also I think the decision might be different if it's a small company not too much accustomed to international trade. Here it was a multinational company who knows well how things go, and they said no, you can do it. And especially one of the arguments is 3 months for the response to the infringement action is the longest time limit we have, and that should be enough. It's not so much elaborated. I think in the case of smaller companies, more complicated supplier interactions, perhaps there would be a possibility to have a small extension, but we will have to wait for decisions with this respect. And now let's talk confidentiality, or shouldn't we?
Yes, we should. As you might be aware, there is a lot of caseload with respect to confidentiality orders, and it took a lot of time to discuss these questions. These discussions are based on Article 58 of the UPC Agreement, Protection of Confidential Information, which says that to protect the trade secrets, personal data, or other confidential information of a party of the proceeding or of a third party, the court may order that the collection and use of evidence in proceedings before it may be restricted or prohibited, or that access to such evidence be restricted to specific persons. So the general approach under Rule 262A, which is the rule that counts here, is the applicant uploads both the original procedural document as well as a redacted version. The judge rapporteur then issues a preliminary protection order. The unredacted version made available to the opposing counsel is then the next step. And then the opposing counsel comments on the order, and the court will decide on the allowability. Some comments to this: as every decision or order from a single judge, it the applicant can request that the decision or the order may be reviewed by the panel according to Rule 333. What is of importance also is that, of course, you can, as an applicant or as a plaintiff, you can present to the court redacted versions of evidence and simply restrict your defense or your argumentation on this documentation. So the general approach is that only when you want to rely on what you want to hide, then of course you need to apply under Rule 262A. What happens if the court does not see the case as the applicant does? Well, then he says that we will not restrict the information to the redacted version. But then, of course, the applicant has the possibility to retract this document from the proceedings and then continue with other material. So there will be no situation that the court says, I don't agree with your allegation that this is confidential information, so I give it to the other party. This will not be the case, of course. If the court decides on the confidentiality, or if the parties have agreed on a so-called confidentiality regime, then the court orders the specific details of this confidentiality regime. The usual way is that there should be at least one natural person of each party who should be allowed access to the information. However, we have seen some cases where the party said, in this case, it is not necessary that a natural person of the party has access, but it is sufficient and enough to have the patent attorney and the lawyer to be put in the confidentiality club, and then they will discuss. In an interesting decision of the local division in The Hague, they decided that with respect to financial information, it is necessary that there is a strict regime with access only for attorneys, and this was without the parties having consented on this. There was also some discussion on a rather curious situation with the local division Mannheim. The plaintiff requested to be allowed to disclose its own confidential license agreement. The local division Mannheim found that neither Rule 172 nor 190 are applicable, since they are intended for disclosure orders against an opposing party. Nevertheless, the requested order was granted based on EU antitrust law. In my opinion, it is also possible to see this case under Article 58 of the UPC agreement directly. The situation was that the plaintiff itself, or the applicant, was bound to confidentiality in this contract, and they needed to be to have the court to decide on the obligation to reveal this information. The local division Munich takes a similar approach on this. And what is not really confidentiality orders, but what is a very important aspect of this system is the access to register. As you might remember, in one of the previous versions of the rules of procedure, I think it was the 16th or 17th version, it was stated that all documents, including pleadings, be made available to the public rather automatically. And then there was fear of the parties, but also of the attorneys and the attorneys at law and the patent attorneys, that this would be detrimental to have a proper defense or attacking strategy. So in the last and final version of the rules of proceedings, this was then altered. But of course, the rules of procedure could not alter the wording of the UPC agreement, and this was made very clear by the UPC Court of Appeal. There is an interest of the public of getting access to the written pleadings and evidence, and this interest must be weighed against the interest mentioned in Article 45, and also the integrity of proceedings shall also be considered. But the general approach will be that at the end of the day, all pleadings and evidence will be published unless you have confidentiality issues for some information. But of course, the way of drafting submissions is of course nothing where we could say as lawyers or patent attorneys, it's confidential how I draft my submissions. No, this is not an argument. The access, and then you have to distinguish between a specific interest to have access to the case, which might be that you are a producer of a similar product, or that you might be sued as a third party in later proceedings, or these situations. And there might be also the situation that you only have I would say an ordinary interest, not a special interest in getting the pleadings. So like a member of a public. And there the Court of Appeal said that at least after the proceedings, there's an interest to have these documents published. And they are not really published, but once they are in the hand of the applicant requesting the document, of course, this person is not bound by confidentiality unless it is specifically ordered. If there are ongoing appeal proceedings, then you can already ask for the pleadings in the first instance. I think this is a bit doubtful, but we have to get used to this situation. I personally had a situation where the first instance proceedings ended by way of accepting a preliminary objection against the competence of the Unified Patent Court, and this case is pending with the Court of Appeal now, and we had a written request from a law firm, from someone who will speak today also, and they were interested in this case, and then we discussed with them rather openly and said, look, of course you have an interest in the preliminary objection argumentation because this is of general interest. What are the limits of the competition of the Court of the Unified Patent Court, but you should not have an interest of getting the action itself, because the action itself on the merits was not treated by the local division in Hamburg. They only decided on the competence. So then the applicant restricted himself the request for access to register on the preliminary objection proceedings, and this was then granted without any further discussion. Next one. We would then skip to point 7 and come back to the costs later.
Afterwards, yeah. The fun for the end.
Yes.
Always the money at the end. So let's talk preservation of evidence first. I will address mainly 3 decisions, one from Milan, one from Brussels, and one from Paris. As you may note, it's all countries who knew a kind of a saisie contrefaçon before the start of the UPC, and they still seem to be a venue for those procedures, maybe because the local practitioners are used to preserve evidence this way. But let's see what we can see from those first decisions. One of the conditions to get an order for preserving evidence is a valid patent. As you know, there's no real examination as to the merits of the validity. And from the 3 cases, we can see that proof of ownership, as well as the absence of the an EPO opposition, was considered sufficient to assume a valid patent. And to which extent the infringement has to be demonstrated. From these first decisions, we see that the standard is, I would say, rather low. It has to be plausible and not proven until the end. In the Paris case, Secor versus Novawell, there was already sufficient proof to show that Claim 1 was infringed. However, the dependent claims and further claims, they still required further evidence to show whether there's infringement or not. And the local decision decided that in that case, this was sufficient proof. In the other 2 cases, they were cases where the preservation of evidence was requested for a trade fair. And both applicants produced photographs of the allegedly infringing products. One also had a poster they saw there and technical opinions from an expert. I think in Italy, traditionally, that was very common, and they still use the same practice. And the local division said that's amply sufficient to grant the order. And in the Brussels case, the ortho apnea case, it was a bit the same. They produced photographs from the website as well as a video shown on the website of the allegedly infringed product, as well as the fact that the alleged infringer was a gold sponsor, showed that they would have a booth and that in the past they showed the predecessor products of the product they wanted to get evidence on, so also considered sufficient. So you don't need a perfect demonstration, but still some proof. It's not only a vague suspicion that was considered sufficient, but we did have no case where the level of proof was below what we can see here. Then I think in preservation of evidence, what is very interesting is what is the standard for ex parte proceedings, because that's usually the most interesting part, because you don't want to know the alleged infringer, what you're looking for and when you're looking for it. So there's 2 of the requirements are urgency and the risk of destruction of evidence. In the Milan and Brussels case, as it was trade fairs, it was considered that the fact that the trade fair would end the day after or 2 days after was sufficient to judge on urgency, because it was materially impossible to hold a hearing within a less than 1 day time limit. For the other case, it was more considered that it was a small market with a few players and word would go around too quick, and the applicant is also a small company. So the ex parte condition of urgency was also considered valid. And as to the risk of destruction of evidence, in the Novawell case of the Paris local division, it was considered that as the main purpose of the preservation of evidence was to get access to digital data, the fact to have an inter partes proceedings could be detrimental, because digital data can easily be concealed or even erased. And as for the trade fairs, the alleged infringers were foreign companies, and so it was considered that the evidence would leave the territory right after the trade fair, and so it was necessary to do the ex parte proceedings, because if they waited until a hearing, there was no evidence anymore, so no interest in an order for preserving evidence. I think the expert question is also quite interesting. We've seen in all three proceedings that the court ordered the expert to be chosen from a national list of experts, which in some countries like Italy is usual. In France, it is not. In the French national proceedings, usually it was the patent attorney of the claimant who accompanied the bailiff to the saisie contrefaçon. And now we have a decision that said the expert is to be chosen from the list of the Court of Appeals, and I may have some critics as to that decision, because this list encompasses 3 patent practitioners only, one of which is a technical judge at the UPC. So if in any further proceedings this was the same approach, we would be in quite of a problem to find a suitable expert from a technical point of view, and also with respect to conflict of interest. So from a personal point of view, and it's only my personal opinion, I hope that this will not be the standing standard for expert nomination in preservation of evidence. Preservation of evidence rings a bell with respect to time limits. There's first the review of the order, which is also quite a frequent means used in such kind of proceedings, and the question is, when does this 30 days time limit under Rule 197.3 start? And here the Paris local division clarified that drawing up the minutes, or the procès verbal, as we say in French, at the end of the preparation is part of the proceedings, of the operations, and giving it to the defendant, giving notice, is the end of the operations. It's not when you leave the premises, it's when you notify the minutes or the procès verbal. And so that's when it starts. So if it's done right at the end of the operations of preserving evidence at the premises, it's at that date. And in some cases, the court allows for a bit more time, for example, a week to draw up this this document than it would be when it's notified after that, at the end of that week. And once the evidence preserved, the claimant has to go to court, start an infringement action, and according to Rule 189, 98 in English, it is within 31 calendar days or 20 working days. And here again the question arises, when does this time limit start? And especially when we look to confidentiality, that's also something that frequently appears in preservation of evidence, that not every preserved document or data is considered by the defendant as non-confidential. And so the time limit that makes this 31 or 20 days start is once the court has made a final decision on the question of confidentiality, whether a party has access or not to the evidence. So it's not from the date necessarily when the procès verbal is notified.
So we will jump back.
We
will now jump back to question of costs. A lot of questions with respect to the costs are not decided so far, so I can stick to the 5 minutes that we still have. With respect to interim award of costs, the Court of Appeal recently said that it's not necessary to make an order on legal costs in case a decision or order is not a final one, especially if the first decision or order was based on a procedural discussion, and then this goes back to the court of first instance. This also applies in summary proceedings in case these summary proceedings are followed by proceedings on the merits. So the final cost award will depend on the final outcome of the proceedings on the merits, and not of the final outcome of the proceedings based on the summary proceedings. A big discussion will be the proportionality. As a reminder, the court and the parties, the costs that are reasonable and proportionate have to be reimbursed by the losing party. And in a very interesting decision, the UPC Court of First Instance, the Central Division in Munich, said that in order to assess if costs are reasonable and proportionate, the court and the parties must have access to information showing at least a detailed description of the number of hours spent working on a particular case, by whom, what for, and at what rate. This, of course, might be subject to confidentiality orders, because, for example, the hourly rates of a law firm is, of course, a trade secret of the law firm. This is for sure, but nevertheless, it might be necessary to reveal this information, at least for assessing the question of proportionality. As you might know, we all work on hourly fees, and these fees have a wide range depending on whom you let work for you. And is of course a question if someone who has a rate which is 3 times higher than another lawyer doing basically the same job is reasonable, or if this is the choice of the party with then the consequences to be borne by the parties itself. The next slide. An important question is security for costs. We are mainly talking about security of costs for costs requested by the defendant and against the claimant. One shall remind that if you sue someone and then you ask this person to give a security for costs because he has no money, I mean, it is in a way your own risk if you sue someone who has not the means to defend himself. So basically the courts are reluctant in this situation, and I think this is the right approach. On the other hand, there are situations where the claimants have no real assets, where there are companies which have basically only a patent portfolio and no other assets. And in these cases, of course, the question shall be treated rather strictly with respect to the security. The Court of Appeal stated in its decision last week, the court must determine whether the financial position of the claimant gives rise to a legitimate and real concern that a possible order for costs may not be recoverable, and or the likelihood that a possible order for costs by the court may not, or in an unduly burdensome way, be enforceable. And then they continued, the burden of substantiation and proof is on the defendant. It is in a second step up to the claimant to challenge these reasons and facts, since there is knowledge and evidence of its financial situation. In this case, it was the request for security was brought up by, I think, Audi and Volkswagen. They had assessed the financial situation of the claimant with reasonable means. They tried to find out what assets do they have. It came out that they are the claimant is a holder of an important patent portfolio, but most of the patents were at the end of their life. So the court of and the main argument of the claimant in this case was, but you did not prove that we don't have the money. And there the Court of Appeal said, no, it goes not like this. If the defendants show that they have done whatever they could do to get information on your financial situation, then it's up to you to clarify that you have, in fact, these means. But there's no jurisprudence like saying that if someone comes from India or the United States or whoever, wherever, then it is difficult to enforce a claim for cost reimbursement. So we need a security. It should be a one-by-one decision, and this I think is the right approach. A big discussion is the question for security for costs and proceedings for provisional measures. As you all know, in Germany, this is not possible to ask for security, which could bring you in very difficult situations, especially when a preliminary injunction is enforceable without any security for the enforcement, not only for the cost reimbursement. And we have diverging decisions here from the local division Düsseldorf on the one hand, and the local division Hamburg. Local division Düsseldorf says it is not possible to ask for security, whereas Hamburg sees it the other way around. My personal view is that if the time is there, and I think this is already the case, if you have like 2 or 3 days, then it should be possible to ask for a security if, of course, all the other conditions are met. But the simple fact that you are in summary proceedings should not exclude a possibility to assess if there's a need for a security. So, thank you very much for your attendance. This was a lot of quick jurisprudence, a lot of procedural questions, and we're happy to have your comments or questions.
Thank you very much for this quick and nevertheless very thorough summary of this big topic of procedural points in the UPC proceedings. We have maybe time for 1 or 2 questions only. Daniel?
You said that amendments to the claims are only possible with the permission of the court, in principle. What if the proprietor then goes and asks for limitation at the EPO under Article 105A or B? Can he torpedo the whole procedures at the UPC?
That's an excellent question, and I would say someone will do it, and then we'll know. I can't tell. Perhaps you have an idea,
no,
or Madame Butin has had some nights without sleep and thinking about what could happen, but I think the future will show.
The interference between EPO proceedings and UPC proceedings is not crystal clear. What we know is that when the Unified Patent Court has decided on a case, including validity, including infringement, and that the case is over, then a later decision, be it by the EPO or by a national court revoking the patent, will not interfere with this decision. It will only end the enforceability of this decision. So in a first step, when the UPC is quicker than the rest and the case is over, then the case is over for these parties. And this is, I think, a main advantage of the UPC. But if you have parallel proceedings going on with different attacks, with different sets of auxiliary requests, then for the time we have no solution.
Okay. Yes, we will later have a presentation dealing also with the relation between EPO and UPC proceedings, but probably not mentioning this very specific but very interesting question. Do we have one final question from the internet?
We have a lot of questions since we have more than 100 participants online, but I will choose 2 because they are smaller questions. One deals with the choice of language. If the language of the patent would be ultimately the main criteria to be to determine the choice of language. That's the first question.
Yes, we are thriving in this direction, and I personally, when we did our first conferences on UPC already in 2013 and 2014. We at that time already said to our clients, have a thorough look to the proceedings or the language of the proceedings before the EPO also, because it's one thing to prosecute before the EPO a patent, but it's a completely different story to litigate a patent in a foreign language. And it was already clear from the beginning that, of course, there would be a tendency, at least if the patent has been prosecuted in English, that the litigation will be in English too. So this is a crucial point for our French clients, for our German clients to think about if it's really always the best choice to bring the patent to the EPO in English.
The very small second question, you have talked on the issue of time limit and respect of time limit, etc. The question is that is it so that there will be a more favorable position towards smaller companies, so SMEs or very small and the rule will be stricter for bigger companies. So is that the message that it's conveyed by the earlier case law? And I can see there has been a movement from the lawyers to the president of the court. So
yes, but what I said before, I will not talk about what may be decided by the judges. I think it would be inappropriate. The only thing that I can say about that, it's the proportionality and the consideration of that is simply in the rules of procedure, and in particular the preamble. So we can suppose that it's among a lot of criteria. There is the time frame, and there is this consideration. It's always a balance of the respective interest, I would say. Sorry if it's not a particularly clear response, but it depends. I will talk like the lawyers.
It's very clear. So thank you very much.
Just wanted to add, I think it really depends on the reasons you bring forward. A big company might have very good reasons to require an extension of time limits, as a small company may have bad reasons to do it. And then we come to the proportionality of and weighing the interests, and in the end, small companies might also not get an extension of time limits if it's not proportional and sufficiently justified.
Thank you very much again, Ina and Konstantin, for this very nice presentation.
So I'm starting at the very time where I was planned to finish my talk, but I will make it anyway, albeit maybe more briefly. I'm very sorry not to be able in person in Strasbourg today for personal reason, and I apologize for being obliged to speak on a video screen. If I am permitted, I would start with a word of advertising, but not commercial advertising, pro bono advertising. For those who are interested in reading the UPC decisions and searching through the UPC decisions, the website of the Unified Patent Court is somewhat frustrating because, first, it does not provide a full text search, so that if you are interested in order to preserve evidence, you may not find all the decisions on this topic. And also only the original text is available, meaning that for the decisions handed down in Dutch or in German, you have no translation. So I hope the court will provide a remedy to that shortly, maybe in the next edition of the UPC website, which will be prepared in coordination with the European Patent Office. But in the meantime, you may consult this website and you will find English translations of all the decisions and a search engine in full text. That being said, I have 5 topics to deal with this morning about the jurisdiction of the UPC. I will discuss first time matters. I will remind you some basics about international jurisdiction of the court. I will say a word about some household issues, discussions between the various divisions of the court. I'll say also something about neighborhood problems, the relationship with the Unified Patent Court and the national courts during the so-called transitional period. And as the American elections approach, I will say, yes, we can, and we can make UPC great now. Let's start with the time problem. The problem came very quickly. Whether the Unified Patent Court has jurisdiction for acts of infringement committed prior to the entry into force of the agreement. And the answer also came very quickly from the local division of Munich, where the rapporteur, in decision on a preliminary objection, said that his opinion that was that the court has indeed jurisdiction over infringement acts committed before the entry into force of the agreement. What remains to be seen, and this is a topic that will maybe broached by the next speaker, Edouard Repose, is what substantive law will be applicable in such a situation. But for the time being, the problem that the UPC has jurisdiction for previous infringement acts is, I think, rather clear. However, there has been a very creative lawyer who has asked a question a little bit differently to the court in the local division in Hamburg. There was previously, before the entry into force of the agreement, there was a case before a German court, a case of infringement, and the German court made a decision that the patent was infringed, but made no decision about damages because the question was bifurcated for a later stage. And instead of going to that national court, the plaintiff, instead of going to the national court for the liquidation of damages, for the assessment of the actual amount to be paid, the plaintiff went to the UPC, and the UPC said that it has no jurisdiction for actions which are only for the determination of damages on the basis of a patent infringement proceedings that have become final before a national court. The case is under appeal, and I think that we will have a decision before the end of the year. Now, the second topic is to come back to basics and to the international jurisdiction of the court. There are always disputes in the field of infringement through the internet, and one such case went before the court. And there was a dispute because the plaintiff has been suing one company where in the place where it found it appropriate for his interests, and it chosen one of the company of the group as the anchor for starting the case, but the other company said we are not obliged to be sued before this court. And the Court of Appeal take a very sound view that where the damage is allegedly caused via the internet, the likelihood of such damage may arise from the possibility of obtaining products or using services from an internet site accessible within the territory of the contracting member state where the European patent has effect. That means, in fact, that it is sort of universal jurisdiction, because whenever you can get products from an internet site accessible from the territory of the CMS, you can have jurisdiction for the Unified Patent Court. The next topic are what I call household issues, and I see two problems here. The first problem is when there are parallel proceedings about the same patent, and a case fiercely disputed is about earth valve, surgical earth valve between an Indian-based company, Merrill, and an American company, Edwards. Edwards, the patentee, has started infringement proceedings against two companies of the group Merrill, the mother company Merrill India, and the German company before the local division of Munich. And in an audacious move, Merrill Italy, a third company, started revocation proceedings against Edwards before the UPC Central Division seat in Paris. And the Central Division seat in Paris took the stand that revocation proceedings in the Central Division are indeed admissible because the actions are not between the same parties. The infringement action is against Merrill India and Merrill Germany, while the revocation proceedings in Paris are initiated by Merrill Italy, and accordingly, the proceedings before the Central Division were not suspended, and the case continues. There has been a somewhat similar situation where a Korean company has started infringement against a French importer of a certain product before the UPC local division in Paris. The manufacturer came as a sort of white knight in the infringement proceedings. He intervened to defend his importer, but he also took the somewhat strange move to start a revocation proceedings against the patentee before the UPC Central Division seat in Paris. So two cases in Paris, but before different division. An infringement case before the local division, and a revocation action before the Central Division. And the manufacturer requested the local division of Paris to stay the proceedings until a final decision of the Central Division. But the local division of Paris did not accept this and decided not to stay the infringement proceedings because the division said that the revocation action against the patentee before the Central Division was likely to be held inadmissible because the revocation action should have been started before the local division. Once the white knight comes in the arena, he must fight in this arena where he came. He cannot change the arena where he wants to fight. As to household issues and the competition between the various divisions of the UPC, you are all aware that one of the main rules of jurisdiction is that the domicile of the defendant is always an acceptable forum, with the proviso that when there are several defendants, it is possible sorry, excuse me, it is possible to sue these all the defendants before the court of the domicile of one of them, provided that there is some relationship to sue him. It is not permitted in international jurisdiction law to use an artificial defendant as an anchor to get the case wherever you want. The defendant must be a serious defendant. And there has been a dispute before the local division of Paris in such a situation as to whether all the companies of the same group could be sued before the local division of Paris. And the local division explained that the fact of belonging to the same group, legal entities, and having related commercial activities was sufficient to be considered as a commercial relationship within the meaning of the UPC agreement. And now I would like to turn to the next topic, which is the neighborhood problem, the competition between the Unified Patent Court and national courts during the transitional period, and also the problem of the so-called carve-out. As to the problem whether national revocation proceedings brought before the entry into force of the UPC agreement, the Court of Appeal has taken the position that yes, it was a case of lease pendants, and it set aside the decision of first instance of the Central Division of the court in Paris. Basically, the case was started in Germany, where Nokia Solutions brought in 2021 a revocation action before the Bundespatentgericht, but the Bundespatentgericht dismissed this action, and the decision dismissing the revocation action was served on the 14th of December 2023. The very day after, the 15th of December, another company of the Nokia group, known as Nokia Technology, filed a revocation action before the UPC. They took another company to take another chance of getting the patent revoked. And also, in the same time, Nokia Solutions lodged an appeal before the Bundesgerichtshof of the dismissal of its action for Germany. So the case in the Court of Appeal of the Unified Patent Court was whether this case, which was brought in Germany before the entry into force of the UPC agreement, should be considered as a lease pendants. The judge rapporteur of the local division in Paris has taken the view, no way, the transitional period and the provisions of the Brussels regulation for the transitional period apply only for those cases brought before a national court after the entry into force of the agreement, not before. The Court of Appeal took a different view and said that we make no difference. The cases brought before the entry into force of an agreement, before the national courts, are to be considered, and having in mind that a second instance and final decision is likely to be handed down within 1 year or so in Germany, we decide to stay the proceedings, the UPC proceedings, until the decision of the Bundesgerichtshof. And there has been also a decision which is in appearance at the first glance different, but which is also very well founded, where the local division of Munich refused to stay proceedings in view of prior revocation proceedings pending in Germany because the situation of the German case shown that no decision could be expected in the short term, such that for a proper administration of justice, it was better for the Unified Patent Court to proceed without waiting for the decision of the German Supreme Court, German Patent Court, sorry. And now I would like to turn to the interesting problem known as carve-out. In many important patent battles, there are several actions pending about the same patent, and typically a situation where an infringement case has been brought, for example, before a German court. And at a later stage, the plaintiff, the patent holder, also start an action before the Unified Patent Court. But obviously, he may not ask for the same thing and sue 2 times for the same reasons. So then the patent holder says, I make a carve-out. I do not make a request, a judgment for example, Germany, but only for the other territories. And this is based on the combination of Article 34 and Article 76 of the UPC agreement. Yes, the decision of the court shall cover, in the case of a European patent, the territory of the contracting member state where the patent has effect, but a basic principle of civil procedural law in all European countries, the court cannot decide, as we say in Latin, ultra petita. The court shall decide in accordance with the request submitted by the parties and shall not award more than is requested. So this is the reason why the court, the UPC, decides that when there is no request for a certain country, it has no decision to make. And we have this case. This case, which is also a fiercely disputed case before several divisions of the UPC. It's about a glucose monitoring device for patients suffering from diabetes. So Dexcom took the initiative to sue his competitor Abbott before the Landgericht Mannheim for patent infringement. First move. Second move, rather obvious, Abbott replied by a revocation proceedings before the Bundespatentgericht. And then Dexcom sued not only Abbott Germany, but 10 companies of the Abbott group before the Unified Patent Court local division of Paris for patent infringement, but it carved out Germany. It said, I request a judgment for all the countries but Germany. And the Abbott companies counterclaimed for revocation, but not only for revocation for the other countries, but also for the German part of the patent. And they submitted that as they were different legal persons, there was no identity of case with the case pending before the German court. And the local division of Paris accepted this position and decided that yes, the plaintiff is permitted to carve out and to exclude Germany from the request for infringement, but this does not restrict a defendant in its challenge to the validity of the European patent which is being asserted against it, such that the companies of the group Abbott which are not sued in Germany are permitted to request the revocation of the patent, including for Germany, before the local division of the UPC. I would like now to say a word which is still in relation of the competition between or more exactly the concurrent jurisdiction of the UPC and the national courts during the transitional period of 7 years. You all know that it is possible to opt out from the exclusive jurisdiction of the Unified Patent Court, and that you have for this purpose to lodge an application to the registrar of the Unified Patent Court. But the formalities are not all clear, and the Court of Appeal took the view, which is in my view absolutely correct, that an opt-out can be lodged only by all proprietors of all national parts of a European patent. So when a patent is being held by two companies who are co-owners, or where some national parts of a European patent are owned by a different company, all the proprietors of all national parts should be should subscribe and lodge the opt-out. And there has been also an interesting decision of the Helsinki local division, and this was a case of, I would say, opt-out tango, where a company has filed an opt-out and decided to withdraw this opt-out the very day before starting an action for infringement against a third party before the Unified Patent Court. So the impression could be that the patent holder, excuse me, has lodged an opt-out to get the impression that he was not going to sue before the UPC, and he suddenly withdrew the opt-out and the day after sued for infringement before the UPC. The Court of Helsinki was faced with the following problem. That very patent has been the subject matter of proceedings before national court, which have been concluded years and years ago. And there is a provision in the rules of procedure and the UPC agreement that it is possible to withdraw an opt-out only unless an action has already been brought before a national court. The patent holder says that can be applied only if the action has been brought during the life of the UPC agreement and not before. And the Court of Helsinki took a different view and said, I cannot see any distinction, and this applies also about national proceedings which have been terminated before the entry into force of the agreement. And to finish, I would like now turn to American questions. But turn to international jurisdiction of the court. On this schematic, you can see in the very middle of the rectangle of the very middle, the Unified Patent Court and the 17 contracting member states to date. In a second rectangle, larger rectangle, there are other countries which are members of the European Union, but not contracting member state to the UPC. And their name is written in different colors. Two states are written in red. That's Spain and Croatia, which are not contracting, which have not signed the UPC agreement, which are not signatory states, and other companies like Hungary and Ireland, who did sign the agreement, but who did not ratify it so far. And there has been a dispute before the Unified Patent Court, which ended by a decision of the Court of Appeal. The plaintiff, Abbott, has requested a preliminary injunction, I quote, for the contracting member states in which the patent is in force. And the Court of First Instance said the patent is in force in Ireland, among other countries, and then I order a preliminary injunction also for Ireland. And the defendant lodged an appeal, and the Court of Appeal took a different view and said, no, Ireland is not so far a contracting member state. It is only a signatory state. I hope it will be soon a contracting member state, but this needs a referendum according to the Irish constitution, such that the Court of First Instance has awarded more than was requested, contrary to Article 76 of the UPC agreement, which I quoted minutes ago, that articles which prevents from awarding ultra petita. I stress this decision because it has been commented, in my view, in an incorrect way by people saying that it was a decision which would prevent the Irish lawyers from representing parties before the Unified Patent Court. That is not correct at all. It's just a decision about look what is requested and apply correctly what is requested by the plaintiff, but the situation of Irish lawyers is not changed by this. They are permitted to represent the clients before the Unified Patent Court because they are member of bar of a European Union. The problem for representatives lawyers is whether they are members of a bar of the European Union or not. And to finish, I would like to quote not Unified Patent Court decisions, but indeed the decision of the decision, an opinion of an advocate general about of the European Court of Justice about Article 24(4) of Brussels I regulation. This article provides that by derogation to the general rule that the court of the domicile of the defendant or the place of the infringement are jurisdiction over a case, when a validity issue is raised, the court, the only court able to decide on validity is the court of the member state in which the deposit or registration has taken place. This was the rule applied by the European Court of Justice in the case known as Gat and Luke. But another case is now pending before the European Court of Justice, and the European Court of Justice is very interested by this case because it raises several questions. The first question is whether when an invalidity issue is raised, this terminates the jurisdiction of the court, including for infringement. And the second question is whether Article 24(4) applies when the validity of a patent is disputed for non-EU territories like Turkey or United Kingdom. And the case went before the Court of Justice. The Advocate General of Cyprus, Mr. Emiliou, lodged a first opinion, and then the court requested a second opinion and handed the case to the Grand Chamber. So we will have within next month a great decision of the Grand Chamber of the European Court of Justice about what to do on validity of patent. On the first issues, the Advocate General concluded without any surprise that when the validity of a patent registered in another member state is disputed, those courts have no jurisdiction to adjudicate the validity issue. And he did not clearly say that in the conclusion of his opinion, but in the body of his opinion, it is clear that the court has still jurisdiction to adjudicate the infringement. That means that for the UPC has jurisdiction not only to adjudicate infringement problems for the UPC territories, but also for the European Union territories covered by a European patent. But the most interesting is for the end. It's that the Advocate General has said Article 24(4) does not apply in respect of the validity of a patent registered in a third state meaning a non-EU state. And in such a situation, the court of the member state may adjudicate, and they are also entitled to not adjudicate on that issues. So for the UPC, that means if the opinion of the Advocate General is endorsed by the European Court of Justice, that the UPC has jurisdiction to decide on both validity of an infringement of a European patent for EP non-EU countries, namely Turkey and United Kingdom, Monaco also, but less important, but that the UPC may also, is permitted to decide only on infringement and decline to decide on validity. So we will have certainly decisions in the future about this very exciting problem, whether we can make UPC with a great scope now. Thank you very much for your attention.
Thank you very much, Mr. Baron, for this very nice presentation. Not unexpectedly, an international European system like the UPC creates a lot of interesting legal questions about jurisdiction. Maybe one question, because we are a little bit running out of time.
Yes, thank you, Mr. Veron. Konstantin Schalmoser here. I just wanted to comment on the decision with respect to Ireland, and there was a recent decision of the local division Hamburg, which I found very interesting. It was a preliminary measure decision based on a unitary patent. The request was filed in beginning of September, and the local division Hamburg granted this preliminary measures for all contracting member states of the Unified Patent Court. And the problem is that the unitary patent was granted in 2023, before Romania became contracting member state. And we have now a decision which is clearly also applicable on Romania, whereas the unitary patent is not valid in Romania, because the unitary patent, of course, will not extend its territorial scope. So we see that there's a lot of difficulties to assess where a unitary patent or European patent or the UPC can actually decide a case.
It's not a question, it's an excellent remark for my excellent colleague.
Okay, then thanks a lot again for this very nice presentation.
We all know that the UPC is a huge shift for patent litigation, and the French ecosystem of IP must be up to this new challenge. And thanks to ceipi, France is even more on the map. After having seen the complex question of jurisdiction with one of the best, if not the best specialist of the UPC, Maître Pierre Véron, it is time to delve into another tricky question. Which law the UPC has to apply, how to determine the law to the merits for the UPC. So, pursuant to Article 1 of the UPC agreement, we will have to determine the applicable law for the settlement of dispute relating to a UP and relating to a European patent with unitary effect. But nevertheless, not all questions concerning EP and UP will be studied today. Our subject is naturally limited to questions for which the UPC has jurisdiction. And as we all know, Article 32 of the UPC agreement limits the UPC jurisdiction to some specific questions. Beyond this question, UPC is considered to have no jurisdiction, and for today, it's not my subject anymore. So, I will not discuss the application of the UPC agreement by national court. We all know that the question is quite irritating and has been rather confused by the interpretative note written by the preparatory committee, which extend the opt-out to the applicable law. According to this note, if national courts are seized by the plaintiff during the transitional period, national law and not the UPC should be applicable. I have already criticized this analysis, which, from my opinion, give too much weight to forum shopping. Coming from private international law, it is not acceptable that by choosing the forum, the plaintiff should be able to decide the law applicable to the patent and should be able to decide the size of the patent. But even if the question is really interesting, it is related to jurisdiction of national court, it's not my subject. And furthermore, I will not discuss rather questions which are not covered by Article 32. Even if a unitary patent is concerned, I will not discuss a unitary patent concerned as an object of property. That being said, determining the law for the UPC is different and even, in my view, more complex than for a national court. The UPC is a court common to 18 contracting member states. And such a peculiarity gives rise to main differences. Firstly, there is no local situation for the UPC. For a French judge, when you have an infringement of a patent owned by a French owner and infringed by a French competitor in France, it's a French situation and a local situation, and French law is applicable. But for the UPC, there is no local infringement. And the UPC, even for this kind of situation, need a choice of law rule in order to determine that French law will be applicable. Secondly, the UPC has no forum. since it is a common court to several countries. This means that UPC judge may not rely on any hierarchy of norms and any private international system. So a UPC judge, as such, is not able to determine which national law applies and whether an international norm trumps a European one. So that's why it is absolutely essential to develop a methodology for the UPC and for UPC judge. And that is the purpose of the Article 20 and 24, which set out a system for the UPC in order to apply, to determine the applicable law. So we will first explain the methodology, and then we will apply that methodology. Any legal system must be based on a hierarchy of norms. A French judge knows that international convention trumps French law, and that the constitution is at the top of the French pyramid. The purpose of the Article 20 is to make it clear that for the UPC, union law is at the top of the pyramid. At the UPC, EU law trumps any other legal norms. Consequently, the UPC is subject to the control of the ECJ. Pursuant to Article 21, the court shall cooperate with the Court of Justice to ensure the correct application and uniform interpretation of union law. Where EU law is concerned, the UPC is bound by the mechanism of preliminary rulings. And it's not a choice, it's an obligation. We all remember the court's opinion 1/09, in which the court held, the ECJ, held that the primacy of union law was not compatible with the previous system, including states from outside the EU. And such a primacy of EU law explains that UPC interprets terms and notions used in the UPC agreement not by taking into account national norms, but by taking into account EU law. EU law is a system of reference for the UPC. Primacy of union law is clearly the main and overriding rule of the UPC, underpinning the methodology as we will see. Having understood the primacy of EU law, it is interesting to delve into the Article 21. One can see a list of texts based on the legal source, such as union law, international law, and national law. But what is really important, in full compliance with Article 20, this phrase shows that there is a link between Article 24 and Article 20, and it enables this norm to be ranked in order of importance. This list must be understood as a hierarchical list. What does it mean? It means consequently the UPC may first base its decision on union law, including, and that's quite important, Regulation 1257. If union law is not applicable, then we will try to find an international norms, and we have a ranking of international norms. First, the UPC agreement, then the EPC, and then if there are other international norms. And if the judge will not find any applicable law among international norms, then he will switch to national law. So Article 24 offers to the UPC its hierarchy of norms. And this case, Panasonic, is quite interesting. The judge then first tried to find, it was related about, it was concerning international service. And the judge tried first to apply EU norm and an EU regulation. But the EU regulation was applicable only for intra-community service. Then no EU law, he has to switch to international norms, and in that case, the Hague Convention. But going back to the hierarchy, we have one question: if there is no union law being applicable, and if there is no international law being applicable, the UPC judge will have to apply national law. Okay, but how to apply national law? Because, as I said, UPC is a common court to 18 member states. Article 24, paragraph 2 of the UPC agreement answers this question. The UPC does not create a complete system of private international law, but the UPC applies pre-existing private international law system. First, EU law containing private international rules should be applicable. What does it mean? Rome II regulation, which is really important for us. Rome I regulation might be applicable in order to determine which national law is applicable. And if there is no EU law, EU private international law being applicable, determining the national law, then we will try to find a conflict of law rules in an international norms. I have not found anyone yet, but perhaps there are some. And finally, if there is no private international law being applicable, no private international law from international source being applicable, then we will switch to national private international law system. But then there is one question unanswered. How are national provision on private international law to be determined? The UPC, because the UPC is a common court to 18 countries, is for that question in the same situation than an arbitrator. The arbitrator has no forum, and he is not bound by the private international system of his seat. And that is exactly the same for the UPC. We don't know yet which methodology will be used for a UPC judge to decide whether French private international law is applicable or Italian private international law is applicable in order to determine the applicable. And there might be some question related to the lex societatis. On reading certain questions, and in particular the Panasonic one, UPC judge seems to favor the theory of equivalence between national law, showing that in fact national law have the same answer, so as not to choose one national law among others. It's a way to avoid private international law and conflict of law rule. Having explained the methodology, we will now apply it question by question in order to test and to determine whether it works well. So, pursuant to Article 32 of the UPC agreement, the UPC has an exclusive competence in respect action for revocation of patent and counterclaim for revocation. Consequently, the UPC shall decide the validity of the patent, requiring to identify which norm to apply. So, following the hierarchy elaborated at the Article 24, neither union law nor the UPC agreement is applicable, justifying then to apply the EPC. The unitary patent being originally an EP, whose unitary effect has been given, the UPC is also applicable for unitary patent. One or two remarks. One remark, and I will switch to the second one. Based on Brussels 1 bis regulation, the UPC, and it has been clearly explained by Pierre previously, the UPC may not decide a counterclaim based on the revocation of a Spanish patent. The explanation can be found at the Article 24, paragraph 4 of Brussels 1 bis regulation. But following the conclusion of the Advocate General in the Electrolux case, this Article 24, paragraph 4 perhaps will not be applicable for a UK designation, meaning that a French court and or the UPC may eventually decide a counterclaim for revocation of a UK designation. And the question becomes, which law will be applied? The methods should be the same, and same reasoning than previously. The EPC would be directly applicable and not through UK law, but directly applicable. There might be another remark, but I will switch on the influence of the UPC decision abroad because of Vienna Convention. We have to take into account that UPC decision will be the one of 18 countries and might be subsequent practice in the meaning of the Vienna Convention having an influence abroad. That's another remark. But so, Second question, after validity, we will apply the methodology for infringement, and we need to distinguish whether we have an EP or a UP. For the first example, we will take into consideration the infringement of a local designation of a contracting member state, a French patent. Union law is not applicable. Pursuant to point B, UPC agreement is directly applicable. The UPC shall base its decision on Article 25 and 26 being directly applicable through Article 24(1)b. The reasoning is a bit more complex for the infringement of a designation of a non-contracting member state, such as a UK one or a Turkey one. UK not being any more a contracting member state of the UPC agreement, the UPC agreement is not applicable. Nor the EPC is applicable on that question, and neither international convention justifying to base its decision to national law. Then we have to determine which national law is applicable. As I said, Article 24, paragraph 2 says that we have to apply first EU private international law, meaning Rome II regulation, and meaning Article 8 of Rome II regulation. And the choice of law rule of this Article 8 is to apply the country for which the protection is claimed. In that case, the protection is claimed for a UK designation in UK. UK law then is applicable by virtue of Article 8 of Rome II regulation, being applicable by Article 24, paragraph 2 of the UPC agreement. After the infringement of an EP, we need to delve into the applicable law for the infringement of a UP, a unitary patent. The application of the hierarchy is not the same. Why? Because we have the Article 24, and it is said, first you have to apply union law, including Regulation 1257. So UPC shall base its decision primarily on EU law. So we have said previously, for an infringement of a local designation of an EP, union law is not applicable, explaining why EPC is directly applicable. For an infringement of a UP, union law, because of this regulation, is applicable. Indeed, you all know that Article 5 of the regulation, 1257, being applicable because being at the top of the hierarchy, governs a uniform protection and holding that the scope of the protection and its limitations shall be uniform. Nevertheless, protection and limitation are not substantially defined by the regulation. Based on paragraph 3 of the Article 5, the regulation does not substantially define the scope of protection, but merely determine which national law is applicable. And following the EU conflict of law rule, the content of the protection of a unitary patent is defined by the law being applicable to the patent as an object of property. It's quite complex, but that's the rule. A conflict of law rules defined at the Article 7 of the regulation is extending from property question to the question of the content of protection. So based on Article 24, the UPC shall apply the national law determined at the Article 7 to define the scope of protection. You all know the connecting factor. It is related to the applicant's residence. If there is no residence, it could be a place of business. If there is no place of business, no residence, it will be German law. And you know that if there is two applicants, it will be the law of the one being indicated first. Having said that, the academic and the theoretical methodology for determining the applicable law of an infringement of a unitary patent in front of the UPC should be the following. Article 24, paragraph 1 of the UPC agreement leads to the application of Regulation 1257 and the Article 5 and 7, justifying to apply the law of the applicant to determine the act against which the patent provides protection, to determine the content of protection. It means, firstly, that the law applicable to the uniform protection may diverge, and secondly, that the Article 25 of the UPC agreement and 26 may not be directly applicable. If they were applicable, it should be through a national law determined by the EU regulation being applicable. I'm an academic. This is clearly not the practice from the UPC. I have identified at least 2 decisions applying directly for a UP, Article 25 and 26 of the UPC agreement, without applying any local norm or without applying the UPC through national norms. It is possible to reconcile theory and practice. Theory requires to apply union law based on Article 24, paragraph 1 of the regulation. Practice seems to apply directly point B, ignoring point E, whereas union law is indeed applicable. So finally, the question is the following. Is the direct application of Article 24 of the UPC agreement for a UP, is that a breach of the Article 24 of the regulation? In appearance, yes, but perhaps not. Some prominent scholar, and it was Pierre Véron in a very illuminating article, consider that applying French law leads to the direct application of Article 25 and 26 of the UPC agreement. One may apply the conflict of law rules in order to determine which national law applies, but at the end, all national law requires to apply directly Article 25 and 26. In a certain way, the conflict of law rules would be superfluous, since in any case, Article 25 and 26 of the UPC are applicable through national law. Applying Article 5 and 7 of the Regulation 1257 may not change anything. It's quite the same than applying a conflict of law rules for a local case. It is unnecessary, but it changes nothing. Like if you try to call someone from France and you do 3-3, does not change anything, but you don't have to do it. For those following this analysis, practice and theory could be reconciled, since at the end, the practical result is the same. The argument is really convincing and attractive. Nevertheless, there might be some argument in order to distinguish the direct application of the Article 25 and 26 and the application through national law. Firstly, one may think about the tricky question of self-executing effect of international convention. It's a very complex question. Secondly, the application of national law may ask whether Article 26 is exhaustive or whether it could be completed by national exception. So there might be some consequences. We hope that at the end, simplicity and pragmatism will win. But no one should forget that at the end, the ECJ may be asked on the correct application of Article 5 of the regulation, because it's a EU regulation. Okay, I have to conclude. We all know that the UPC may also have to decide contractual question. Why? Article 32 says the UPC shall have exclusive competence in respect of counterclaims concerning license. And Article 47 of the UPC is taken into account the license in order to determine who is entitled to bring action before the court. So in both situations, the UPC may have to apply and interpret the law of the contract, the lex contractus. We go back to the methodology. There is no European law on contractual issue. There is no international norms. So we go back to national law. And we go back to EU private international norms. Rome 1 regulation is applicable. What does it mean? It means that if the law chosen by the party is a US law, the UPC will have to apply US law. And if it's a Chinese law, the UPC will have to apply Chinese law. And there is something, and I will conclude on that, really interesting, that there is a debate among French and German private international law academic related to the Article 4 of Rome II regulation. And the question is, who is the debtor in a contract of license? Who is the debtor of the characteristic performance? In France, we think that it is the licensee, and others think that it will be the licensor. It will be really great to have the opinion and to have the interpretation of that question by the UPC. So in order to conclude, it seems that the methodology works quite well. It remains that the direct application of the Article 25 and 26 could be seen as a legitimate simplification. I hope that the ECJ one day will not consider it as an oversimplification. Thank you.
Property over Europe, and I'm still happy to be a member of the famille de ceipi, as Mr. Roboul used to say, previous Director General of ceipi, just to go back to history. But I have a great responsibility today, not only because I'm speaking on behalf of the European Patent Office, well, actually on behalf of the Boards of Appeal of the European Patent Office, but because I have to finish in time to have lunch. I don't want you to starve. And this means that not only I will try not to speak too fast, but I try to focus on the essentials of my presentation. Focus on essentials is something I always tell representatives to do. And so it's a test for me whether I'm able to do myself what I ask representatives to do at the Euro proceedings. And these also will mean that, if I'm... So, first thing, j'utilise la souris, peut-être.
Ça devrait être bon.
Okay, it works. So this means that I will go briefly through some of the slides which are, where the content is not really essential for our discussion on the relation between UPC and EPO proceedings. First of all, I would like to say that the Boards of Appeal are the first and final judicial instance in procedures before the EPO. So that's the first point I want to say. And that, just immediately going back to last point in the court, that European and United patents may be subject to validity proceedings in parallel to or after proceedings before the PO, including the appeal. Just to give you an idea of the number of cases dealt with by the EPO, for those that do not have an idea, at Boards of Appeal we deal about more than 2,000 cases that are received, and since we had a backlog, we were able in 2023 to settle more than 3,000 cases. That's the amount of cases we deal, and the great majority of that is in inter partes, that is in opposition proceedings, appeal from opposition proceedings. Let's just move to the next slide and focus on the relationship between EPO and UPC. So these are overlapping and concurrent jurisdiction as concerns the validity. Because the EPO, we are not, of course, at the EPO, we only deal within the framework of the EPO, and we are not concerned with infringement. Of course, the Boards of Appeal are also competent in decisions of the first instance in examination proceedings, but after grant, opposition, the EPO is competent, the Boards of Appeal might be competent, the appeal is filed, and UPC and national courts might be competent depending on whether the validity or revocation action is stayed. Now, you see that in this slide, what is important to see is that there might be, for instance, revocation in one jurisdiction, and that might affect the other jurisdiction. When I speak of revocation, there is also another possibility. One was mentioned before, where I wouldn't like to answer to that. What happens in case of limitation and pending UPC proceedings, and other cases where the patent is maintained in amended form before the boards of appeal. That is, there is a final decision maintaining the decision the patent in more restricted form than it was granted. I would like first to concentrate on procedural issues and overlapping jurisdiction, concurrent jurisdiction that might give the idea of some duplication of proceedings. What are procedural tools possible in order to avoid these, if it is at all desired to avoid this? From the side of the EPO, we can accelerate the proceedings. So the EPO, as the office, that is the first instance, can accelerate the opposition proceedings on request. They will do that if there is a pending UPC proceedings. The board can do that as well. It's at discretion of the board. I'll come to that later on. And the UPC has the possibility of staying the proceedings. I will also come to that point later. Before the EPO, as I said, the EPO will accelerate the proceedings of the opposition if it is informed by the UPC that infringement action are pending. Parties may also request it. And the DPO then will act as quickly as possible. Just to give you an idea of the timetable of opposition proceedings, normally, after grant, you see 9-month opposition period. That's regulated in the EPC, cannot be changed. Then there is about 4 to 6 months for a reply. It's just an example. It doesn't cover all cases. And after the reply, another 4 to 6 months before summons to all proceedings are issued. And then another 4 to 8 months before all proceedings take place. And then another 1 to 3 months before decision issued. You see, it's quite a long time. So over 1 year. Nearly 2 years before a decision from the grant and when opposition is filed to come to a decision. The EPO has issued a notice in which they say that they, in case UPC proceedings are pending, they can accelerate and they can do that in a very short time. This has to be seen, but you can see that in the graph, the periods can be shortened up to 8 months from the filing of the position. A decision might be issued. I say might be issued because already one difficulty there, for instance, if you see the time between the summons and oral proceedings, which is reduced to 2 months, is really the minimum as set in the convention. So reducing that is possible, less than 2 months, but only with the agreement of the parties. And 2 months is a very short time. In case of 2 months, my experience is that it is very likely that the parties will say, well, I'm sorry, I already have serious reasons for requesting postponement of the oral proceedings because I was summoned by another court or any other serious reasons. So that's really the theoretical case, but it is, I think, possible. If we look at the boards of appeal acceleration proceedings, then in this case there is a discretion of the board to accelerate the proceedings, and in particular where infringement or vacation proceedings are pending, and then the board will give priority to this case and adopt a strict time frame. I will give you an example of what is a strict time frame. The acceleration of proceedings is regulated in the rules of procedures of the boards of appeal in Article 10. The UPC has the possibility of requesting that the boards, the office, accelerates the oral proceedings. And in fact, what happens in practice when there is a pending proceedings before the UPC, you see down in the slides, a reference to the UPC-EPO agreement on data exchange between the register. In practice, what happens is if there is pending UPC proceedings, the board is informed. Normally, I would receive an email from the registrar telling me that, look, we've been informed there was an inquiry by the UPC that whether there is something pending before the boards. So I received this information immediately, and then with the board we decide whether we should, of our own motion, accelerate. And this is the timetable of appeal proceedings. So here will be short. So from the time the decision is taken by the Department of First Instance, you have 2 months for filing the appeal, the notice of appeal, sorry, and then another 2 months for filing the statement of grounds of appeal. And normally we would give 4 months of time to filing the reply. I will stick to the terms as used in the rules of procedures. 4 months, then some time will elapse between the reply and the summons to all proceedings. The time between is due to the backlog. But if we set priority, so that would be the case would be immediately dealt with. So the time there will be short, and what will count there is the time for the board to prepare, to look at the case in order to issue the summons and prepare the preliminary opinion. And the preliminary opinion is not only the preliminary opinion of the board, it's a preliminary opinion, it's not only the preliminary opinion of the rapporteur, but is the opinion of the board. That is, it is discussed with all the members of the board before it is brought to the attention of the parties. And then normally 4 months for notice before the oral proceedings, and then 1 to 3 months before the written decision is issued after the decision has been announced at the oral proceeding, which is the normal practice before the board, that the decision is announced at the oral proceedings and the decision is issued within a period of 1 to 3 months, and that's also in the boards of appeal. This time can be longer, but normally should be between 1 to 3. If we adopt a strict framework, just to give you an example, it's a case that was dealt with in my board, and it was, I think I've seen, there is a representative here who was involved in the case. So it's just to give you the facts. Of course, I will not say anything about case where I'm involved. But the decision was issued by the opposition division, was issued in December 2022. Appeals were filed, the notice appeals were filed on February 2023, and then intervention was also filed. I just give you the essential of that case. And in this case, there was a request for acceleration filed by a national court. It was the court, the tribunal of Munich, but we have done exactly the same if it were the EPC. And the court of Munich informed the board that the hearing was scheduled for the 1st of February 2024. And the board decided to accelerate the case and adopt a strict framework by indicating what were the next step in the proceedings. That is, indicated the date in July as for date for reply to statement grounds of appeal, and indicated what was the date for oral proceedings without issuing the summons yet. And then the first statement grounds were filed in April. The period was extended in view of the substantive submissions made by the parties, but still in September, the last reply was filed on the 4th of September 2023. Summons to all proceedings were issued with a short notice, so on the end of September for the 1st of December, and the communication with the preliminary opinion was issued sometime later on, and somewhat about the end of November for the oral proceedings that were held on the 1st of December. And the decision, and on that day, on the 1st of December, the board announced after the oral proceedings took place that the patent was revoked, and the decision to revoke the patent, the written decision, was issued at the beginning of January, so the boards were working during, the board members were working during Christmas. Now, stay of proceedings by the UPC. There is an order of the UPC appeal court which gives some principle there. And I think the main principle is that normally the court will not stay the proceedings. And the mere fact that the revocation proceedings before the UPC relate to a pattern which is also subject of opposition proceedings before the EPO is not sufficient to allow an exception to this principle. Interesting is also that the court said that decisions in which the UPC and EPO issue different rulings on the revocation of a European patent are not irreconcilable. And I think also very interesting, the next point, the interest of harmonizing decisions on the validity of European patent can be promoted by ensuring that the body that decides last can take the decision of the body that decides first into account in its decision. And the court also said an exception is when a rapid decision may be expected from the EPO. Acceleration as such is, however, not sufficient for establishing the expectation of a rapid decision. Now, one point, I would like to give my opinion on one point, but not from the side, because I'm not giving opinion on what the Court of Appeal, the UPC says, but an opinion from my personal opinion on the side of the EPO is that I would very likely, personally, I would very likely apply the same principle when the opposite is happening. Whereby perhaps the concept of rapid decision would be a bit longer than for the UPC. That is, if I am aware that in 6 months there is a decision, it is likely that the UPC will take a decision in a case for revocation, then I would probably, or personally, I would stay the proceedings, or I would wait until the case is decided by the UPC, in order to, if necessary, well, if the patent is revoked by the UPC, then these would have the effect on that part of the European patent that is a unitary patent. But in case that we take into effect what the UPC, take into consideration what UPC said, that would be, from my point of view. But then in practice, this has not happened yet. So we will see what the future will bring us in cases like that. But just to give you an example of stay, that's also by the UPC, that's also a case that was before my board. So it was case 308 of 2023, and the UPC, that was the Baltic local division that stayed the proceedings. That's again a case of a heart valve, like the one I mentioned before. There are a bundle of cases concerning heart valves. The case mentioned by Mr. Maître Véron. And here the Baltic Division stayed the proceedings on the 1st of January 2024, and the Board of Appeal accelerated the appeal proceedings, and the decision was issued, the written decision was issued on the 16th of July 2024, while the patent was maintained in amended form. And the court gave an order in which it determined the timetable for further proceedings and gave the time to the defendant, in particular, gave the time to the defendant to file an amended defense and counterclaim for revocation to be filed on tomorrow, actually. So when we speak about, that was the point about procedural mechanisms, so stay proceeding, acceleration proceedings. We've seen UPC will normally not stay the proceedings. We will accelerate the proceeding as much as possible when this is appropriate. But what are other possibilities for harmonizing? We were all working with the same, under the same EPC. Publications, you see judicial exchange, publications, exchange fora, and here I would like to cite, for instance, the annual judges seminar in Venice. We also have the case law conference in Munich. We also have exchanges with members and judges. For instance, we had last year and this year also in Munich discussions, open discussion on issues like, for instance, last year we had, just to cite an example, plausibility and amendments, intermediate generalization. And this year, for instance, one issue was in particular sufficiency of disclosure. So there are ongoing discussion and information and development of case law, that one in particular what the Court of Appeal mentioned in that order, one mutual consideration, taking into consideration what the other court has done. And coming to the substance, and I would like now to finish my presentation with a reference to the last case pending before the enlarged board. I won't say anything into detail because I was in the board that referred the question, so I just stick to the facts of what is in this decision, and this decision concerns the fact of whether the description should be used when interpreting the terms of the claims. And so these are the three questions that were referred, and I would just like to draw your attention to a point in the reasons of the referring board of the decision with which the board referred the case to the enlarged board. So it's not me speaking again. I'm not giving any, just stating a fact of the board here. Point 6 seems desirable to come to a common understanding on these questions, and especially point 6.1. The Court of Appeal, UPC, has taken the first step in this direction by referring to the regional case law developed by the enlarged Board of Appeal of the European Patent Office in days when the enlarged board had adopted Article 69 and its protocol were applicable also when assessing patentability. No comment on that, just to show, well, here perhaps the Court of Appeal had gave an input. That's a fact there in the referring board decision. That's all. Thank you very much.
Thank you very much, Giovanni, for this nice overview. And you stopped with a climax, so to say, but we do not all know how the story will end or continue. Are there any questions?
Yes, just one question. On one of the slides, you are mentioning the fact that the Court of Appeal said that the fact that different decisions are reached towards the validity of a patent may not be irreconcilable. That's what is mentioned. Does the Court of Appeal say how they can be reconciled a different decision on the same patent?
You're speaking about the UPC Court of Appeal.
Yeah.
So I would leave that to the UPC Court of Appeal. And if you read the order states that they are not irreconcilable because the first one takes precedence of the other one. And as it was stated there, it gives the possibility to the other deciding body to take that into consideration. But I can't say more than that.
May I add one comment on this question? For instance, there may be different prior art in the two proceedings. First of all, different pieces of prior art. And second, the prior art, according to, which is considered for opposition proceedings, is not identical to the one considered for UPC proceedings, older national rights. So already these 2 points can lead to different decisions.
Definitely. From that point of view, I must say that the cases are not always the same. That depends very much on what has been put forward before the deciding body. So that might be And that's why, I mean, even the boards of appeal, if you present a case before one board, the other board on the same patent may come to different decisions depending on the material, on what they have in front of them. So from that point of view, they certainly not reconcilable.
One further question?
More a comment. I remember once there was a discussion between Sir Robin Jacob and the chairman of the Legal Board of Appeal, and Sir Robin Jacob wanted absolutely to hear whether the EPO will follow the case law of the UPC, and the reply was there, it depends, which is exactly what you said as well. There is no guarantee that they will follow, and I think it better. And if the problem is, if there are diverging decisions, what will happen with the claimant and the defendant? If damages have been given for a patent which is revoked ultimately and vice versa. There are still lots and lots of questions not answered. That's all I want to say.
Thank you very much, Andreas. Thank you, Jan, Andreas, Stefan, for organizing this conference. Such an event is, in the field of patent law, is very important for the research department of CEPI. It is highly complementary to CEPI's diploma patent litigation in Europe, which is accredited by the UPC to deliver the European Patent Litigation Certificate, allowing professionals to plead before the court. I'm also greatly honored to be part of a program with such distinguished speakers. Thank you for your time and for coming to Strasbourg to share your knowledge and your expertise. Concerning the tricky question of the technically qualified judge and potential conflict of interest, there is a need, first of all, to identify where the potential issues stands. The situation of full-time judges can sometimes be delicate to analyze, depending on the circumstances, but it seems clear that the most challenging case is that of part-time technical judges. Indeed, part-time legal judges keep in their country of origin their independent status, of which impartiality can be considered an elimination. The case is similar for professional technical judges in countries that have such a system, like Germany, Netherlands, etc. So, identifying. Maybe from here it doesn't work? No, okay. Identifying the issue. Potential conflict of interest for technical and part-time judges. What is a particular issue of private practitioner? In 2002, 51 technically qualified UPC judges were appointed, and 43 of them were patent attorneys from law firms and in-house companies. The trickiest issue lies in the fact that many of those part-time judges are private practitioners in the meantime. The UPC Administrative Committee obviously decided to recruit the best European specialists from various countries. But this implies that they come from the most part from private sector, from the most important law firms and industrial companies in Europe. The risk of conflict of interest is therefore very real, or at least impossible to evaluate. One can recall Article 17, paragraph 4, paragraph 1 here, and I want to talk about paragraph 4 right now, which provides that
there is a problem raised right away in the agreement that part-time judges, technically qualified judges, shall not exclude the exercise of other functions provided there is no conflict of interest. And paragraph 5, in case of a conflict of interest, the judge concerned shall not take part in proceedings. Here is the main principle. The European Court of Human Rights had, of course, to decide that professional, financial, or personal ties between a judge and a party to the case, or his or her counsel, may raise issues of partiality. This is obvious, the case when it's possible to find some overlaps in time between proceedings, with a person in the two function of judge in the one hand and legal representative of the opposing party on the other. But it can also be deciding, depending on the circumstances, that a delay of 3 years between the two relations between parties can lead to a lack of impartiality. Concerning the financial interests, those of the judge in question must be directly related to the subject matter of the case. Oh, sorry, this was this slide. It was this slide. So you have the references of, there are many decisions of the Strasbourg court, but a few of them are cited here. Importance of this concept of impartiality. Well, there are many lawyers here, so you are maybe fully aware of this, but I want to recall how important it is and how it is expressed by the courts and by the European courts. More broadly, the preamble, I decided to cite, and I was happy that Edouard Repos this morning cited Article 20 and 21 of UPCA, because I only wanted to recall the preamble of UPCA that recalls the primacy of union law, which include, etc. And what is important for me here is the Charter of Fundamental Rights of the European Union and the general principles of human law. And mentioning at the end of the paragraph the need of an independent and impartial tribunal. As a consequence, the CGEU case law is particularly interesting to determine the meaning of the impartiality condition within the context of the functioning of the UPC. First, there is a principle of effective judicial protection. The principle of effective judicial protection is a general principle of union law, as it was mentioned 1 second ago. It is now expressed in Article 47 of the Charter of Fundamental Rights of the European Union and derives from the constitutional traditions common to the member states. And the CGEU decided clearly in this sense. The protection conferred by Article 6, paragraph 1 of the European Convention on Human Rights is thus implemented in union law by Article 47 of the Charter. This is without prejudice, however, to the fact that in accordance with Article 52, paragraph 3, yes, it's here, of the Charter, insofar as the right to an effective remedy or to a fair trial contained in Article 47 of the Charter corresponds to a right granted by the European Convention on Human Rights. Its meaning and scope are the same as those conferred by that convention as interpreted by the European Court of Strasbourg. Article 52, paragraph 3 of the Charter aims to ensure the necessary coherence between the rights contained in the Charter and the corresponding rights in the European Convention on Human Rights, without prejudice to the autonomy of union law and the Court of Justice of the European Union. And you saw this in the first paragraph of Article 47 of the Charter. Sorry. Second, there is a necessity of an independent and impartial tribunal that is inferred from Article 47. The right to an effective remedy guaranteed by Article 47 precludes disputes concerning the application of union law from falling within the exclusive jurisdiction of a body which is not an independent and impartial tribunal. The court refers to the European Court of Human Rights case law, which insists on the question whether the body at issue presents an appearance of independence. What is at stake is the confidence which the court in a democratic society must inspire in the public and first and foremost in the parties to the proceedings. The CGEU therefore refers largely to the European Court of Human Rights case law on impartiality within the meaning of Article 6, paragraph 3 of the European Convention on Human Rights, and adopts both subjective and objective tests. I don't have time to detail this. In a few words, the subjective test refers to the personal convictions and behavior of a particular judge, while the objective test needs to ascertain whether the tribunal itself, and among other aspects, its composition, offers sufficient guarantees to exclude any legitimate doubts in respect of its impartiality. It is important to emphasize something I think you all know, that appearances are particularly important. The Court of Strasbourg often quotes a famous English aphorism: justice must not only be done, it must also be seen to be done, because what is the most important is the confidence with the courts in a democratic society, and must inspire in the public. I prefer to cite this rather than the aphorism, exactly what Lord Ewart wrote in 1924. It is not merely of some importance, but is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. For instance, and I dive directly into the code of conduct, and then we will go elsewhere. But we have this this is Article 4, paragraph 10 of the code of conduct of the UPC. I highlighted what is most important to my view. A judge should be aware that activities which are sponsored, etc., create an impression of dependence or partiality of the judge. So this is really important, the impression of impartiality. That's also why the subject is difficult, because the judge can say, well, I never had this party as a client, but he must ask himself or herself if the public, we will see the precision about who is the public in the code of conduct, but one may keep in mind that there is a question of appearances. What about impartiality in the UPCA and the statute of the UPC? The UPCA explicitly refers to impartiality of its judges in Article 17, entitled Judicial Independence and Impartiality. I mentioned it already, so I win some time. Paragraph 1, paragraph 2, with quite obvious rules. The judges shall not be bound by any instructions, etc., etc. My point here is the paragraph 4, part-time judges shall not exclude the exercise of other functions, provided there is no conflict of interest. Moreover, the statute of the UPC, first annex of the UPCA, as you know, adds further details at Article 7. In particular, paragraph 2 of Article 7 provides that judges may not take part in the proceedings of a case in which they, and you have a list, and I won't read the article you have on the screen. What is, for me, may lead to a discussion would be the letter D and the meaning of the interest in the case in relation to one of the parties. The question will be, and the question is, and the code of conduct we will see tries to answer this question, to what extent the interest shall be considered in relation to one of the parties. What is the proximity of this relation? So how the system, the legal framework, solves the issue? We have procedural remedies and this, famous, I don't know, code of conduct for judges. The procedures under the UPC system. Two procedures. The preventive measures is the abstention from the judge, and what I would call an a posteriori measure is the recusal. The abstention, article paragraph 5, I will win some time, dear Andreas. In some cases, the judge can inform the President of the Court of Appeal or the Court of First Instance that he or she considers that he or she should not take part in the judgment or examination. The President can also decide that a judge should not sit in a particular case and notify his or her decision by writing, explaining its reason, which is in line with the European Court of Strasbourg case law. We have every reason to believe that judges are very careful in applying these rules. On the one hand, they are all fully aware of their duty of impartiality as a judge. Indeed, this is obvious for professional judges, but also for private lawyers and counsel. For instance, the EPI, the Institute of Professional Representatives before the European Patent Office, the EPI Code of Conduct provides that any member of the Institute, first article, should act as an independent counselor by serving the interests of his clients in an unbiased manner without regard to his personal feelings or interests. Concerning attorneys at law, of course, independence is a fundamental concept governing the exercise of the duty, and I would not say all the countries, but in almost all the countries, because I'm not sure of this, it's a constitutional principle. Despite this optimistic remark, it is obvious that a party must be able to invoke the risk of bias on the part of one of its judges and eventually provided for in the rules of procedures. What I call a posteriori measures, this is called, this is a recusal. You can find it in the rules of procedures, Article 346, application of Article 7 of the statute. So this article governs this process. I won't go into the every detail of this article, but on paragraph 1, a party can object to a judge taking part in proceedings and notify this objection to the president of the court of first instance or appeal as soon as is reasonably practicable in the circumstances. This is not a strict rule, so reasonably. This is not a strict rule to invoke in limine litis. The reasonable rule gives some flexibility as avoiding that disloyal litigant notify a partiality objection late in the proceedings. Considering the importance of appearances, the rule is important and compliant with the European Court of Strasbourg case law. And in general, these kinds of proceedings are rarely implemented and are often unsuccessful when we study case law. But in any case, litigators should have in mind that not using the possibility of Rule 346 could imply the inadmissibility of further appeals on this ground, because he or she unequivocally waived this ground for disqualification. The European Court on Human Rights does not seem so strict, even if it's quite complicated, but its case law, I would say, does not seem unambiguous on this question. The President then, back to my rule 346, the President then decides whether the objection is valid. It's the paragraph 3, not on the screen, and can refer to the Presidium in case of difficulty, paragraph 4 of the same article. As I was saying, the European Court requires the court to give reasons for its refusal to accept an application for recusal, which is the case in the UPC framework. So the principle, there is no reason that this principle should not be respected by the President or the Presidium. Paragraph 6 of Rule 346 paragraph 6 provides that the panel assigned to the proceedings may decide to continue with the proceedings or to stay the proceedings pending the final decision of the President concerned or the Presidium. One can imagine that no decision has been made by the judge or the panel, as the objection shall appear early in the proceedings, and that the President or the Presidium may decide quickly. Nevertheless, caution is advised, and one may keep in mind that it may be consistent to examine concretely whether the challenged judge was in fact able to influence the outcome of the dispute. Then we arrive to the code of conduct. Two articles, the content and the proceedings, the implementation of the rule that are in Article 5 and Article 6 of the Code of Conduct. Article 5, the most important substantive rules are set out in Article 5, entitled Reasons Excluding Participation in Proceedings. Paragraph 1 here on the screen seems quite obvious but necessary, so I won't make any comment. Just a few words on paragraph 2. This paragraph outlines that a judge must not participate in a case if they acted as an advisor of the case, were a party to the dispute or represented the party, etc., etc. It's in line with the other articles I already mentioned. Paragraph 3 then explains when the doubts of partiality can occur, notably, and as you can see, A, E, F, G. I chose to put in light only a part of this paragraph, and I invite you to read it. You have some delays, 5 years in one for the first example, 3 years for letter E, etc., etc. Letter F can be very, you can feel it very, a patent attorney can feel it very strict, because he's only a contact person. He didn't made much more than this. And last rule here on this paragraph 3 is when the judge has been working for a competitor. Paragraph 4 makes this clarification, advising a third party, and this is also quite difficult on a case-by-case basis. Advising a third party in the technical field related to the dispute does not automatically raise concern of bias, but the judge should be cautious the greater the similarities between the advice and the matter in dispute. So this is not a question of person, but the matter in dispute, the more significant the dispute's outcome could be for that advice. And the more aligned the interests appear, the higher the potential concern for bias. Secondly, implementation in Article 6 of Code of Conduct. I will be quick. Klaus Grabinski expressed this very clearly with what he called the traffic light principle. Red light, the technical judge has identified the traffic light interest, and well, there is an abstention in that case, and we don't have to ask him anything. Yellow light, there might be issues, and we will discuss because this requires further informations. And green light, the judge sees no conflict. As a conclusion, because I see Andreas not far away from me, there is no really. We have. I hope I could be clear describing the legal framework on this topic. But in the end, at the end of the end, there is no suspense about the final answer. This is and this will be evaluated on a case-by-case basis. Based on the case itself, on the context of the judge's position. We know that the technical judges themselves are wondering, and that is important for the success of the system, that wins the confidence of the users. So it's important to try to specify the rules should apply and to identify the possible dead-end situations, and I finish with this. As a matter of fact, one can be pessimistic. Some people consider there will always be an interest at stake. I quote one of them, even in case of an absence of conflict, as an attorney or court user, you always have an interest to make a case law in direction or another for a strategic file. But even if the comment seems true, the interest mentioned here appears too indirect to be considered for the enforcement of impartiality principle in practice according to case law. In fact, we can be optimistic, and I will end with an optimistic remark, considering the court is able to enter a virtuous circle. with an effective operation that will resolve the problem of conflict of interest. On the one hand, this will make it possible to recruit full-time technical judges as soon as possible. On the other hand, it is known that the distancing in time reduces the risk of partiality. And well, we have remarks from the European Court. I can share the reference with you, or maybe it's here. Yes, it's here. For example, the idea, well, the rule, the 5 years rule, was judged by the ECHR, but the Court of Strasbourg can, on a different case, we have a 5 years delay, and on a case they can decide one thing, and on the other case decide a different thing. So it's really on a case-by-case basis. But I think it's important to have in mind that we have some case law. We don't have only this code of conduct. It does exist within this legal framework. In the end, time should play a role in reducing the risk of partiality, but only in full-time, only if full-time technical judges are appointed, and it does not seem conceivable that practitioners in law firms accept to limit their activity vis-à-vis clients or future clients because of their status of legal judges. So we can be optimistic, and in the meantime, despite the strict rules of the Code of Conduct, we cannot bet a situation of conflict of interest will never occur. Thank you for your question.
Is not the official position of the UPC. It's my personal views and practice. So far, I have 2 cases. One has been stayed, is the Mala case, and the other I'm going to have oral proceedings in January. So after the disclaimer, I would like to dig a little bit on the practical side of allocating a TQJ. Of course, this is my experience. The president of first instance is there, so she may intervene and correct me in the general cases. So the first step is that the president of Court of First Instance or Court of Appeal proposes 1 or more cases to the TQJ. If there are more, it's because they are related. So the TQJ then runs an internal conflict check according to the Code of Conduct. Internal means that it's internal, yes, thanks. It's internal to the patent firm the judge work with if he's a patent attorney, and we will speak. We will say something more later. Then the TQJ shares the result with the president of first instance or appeal, and there is a possible discussion of the situation with the president. And then it's up to the president to decide on asking the parties when the conflict is minimal and needs the approval of the parties, or allocating directly the TQJ because there is no conflict. I want to say that normally the internal conflict check is quite easy. It takes some time, but it's quite easy with regard to the parts and the representatives. There is the last comma of Article 5 talking about competitors, and then there it's more difficult because first we have to find the competitors. Suppose that we are in a telecommunication field, which I work in, and then you have many big competitors with many firms under their property. It's very difficult to choose, let's say, 10 of them because you cannot run conflict check for 100. And then you run a conflict check for each of them as it were a brand new conflict check. So it is very time consuming. I
did that, and I discussed the result with the president of the Court of First Instance. By the way, I have 2 cases, but I have been proposed several others, but there were criticalities and conflicts, so it could not be allocated. So in the positive, if all is good to the eyes of the TQJ and the president of the Court of First Instance or Appeal, then this president allocates the TQJ and the access to the files is granted. Now, what are the takeaways from this practical workflow? The process is, according to my opinion, is very rigorous. There are no exceptions unless the parties agree. It's very short-paced. It is done within 1 week normally, and it is very friendly by email or phone. So it's not something that we feel as cumbersome in itself. Now, after having said something on the allocation, I would like to talk more about working in the panel. So the judge, the TQJ has been allocated, and now there is involvement of the TQJ in a panel. Okay, so the DQJ is immediately involved in every activity requiring the opinion of the members of the panel, other than the judge rapporteur. Again, here it is not a rule, it is the practice I can tell you, and it is very nice to be immediately involved in every activity, even in issuing orders, which most of the time are legal, so the contribution of the TQJ is very limited, but still, both out of curiosity and because the final decision has to be signed also by the TQJ, it's nice to have. And the TQJ may take part in oral proceedings in the interim phase. It actually happened in my first case because I asked for that, because I wanted to see how it was managed by the judge rapporteur and what could be the argument of the parties. And that was in the Mala case for competence. And then we discussed, after the hearing, we discussed the matter, and I made my points, of course, with limited contribution, and Mr. Edike in that case took his decision and issued the order. And now we have the decision of the Court of Appeal. So what about contribution of the DQJ? First of all, what I've just said, discussing point of law, also revising draft orders as far as it is possible for a TQJ. And most importantly, drafting a technical assessment of the case for the panel. So technical assessment mean patentability and formal matters according to the EPC. And then there is a discussion of the assessment with the panel, which is very busy normally. So the assessment, the discussion comes at the end of the interim proceeding, the written proceeding. And of course, attending the final oral proceedings and issuing decision with the panel. So as to formal requirements, there is an assessment of added subject matter, extension of protection, admissibility of the amendments, exclusion and exception to patentability. On the side of substantive law, we have sufficiency of the description, novelty, multi-step industrial application. This is okay. So now I'd like to speak on interpretation of the claims, partially superposing my presentation with that of Andreas, but maybe it's a different point of view. We have the decision of the Court of Appeal about interpretation, and I must say personally I like it very much, the way it is worded and the guidelines they give us. These are a few points from the decision. It must be done, the interpretation, with regards to the claims in accordance to Article 69 and the protocol. And Article 69 applies equally to the assessment of the infringement and the validity of the European patent. I have to underline that here in the first item we have with regards to the claims. So claims are the important part. The description and the drawings, on the other hand, must always be used as an explanatory aids for the interpretation of the patent claim. We will see a few invented examples later on, but I'd like to stress here that the decision doesn't say that we have to interpret or we must interpret the claim according to the description and drawings, but it is to be used as an explanatory aid. And it is not the only explanatory aid. It doesn't say so, and therefore I interpret that as for the fact that we can resort to other explanatory aids, which are evidence, arguments, and testimonies from experts, and so on. So, and common general knowledge, of course. Here it comes a decision of the first case ever at the UPC. At the first instance, the patent description may represent a patent's own lexicon, a guideline which is also seen in the Board of Appeal decision, in some at least. But it says that the feature has to be seen in context and in the application as a whole. So it may represent a patent's own lexicon, but it depends on the context. The patent claim is not only the starting point, and I think this last point is very important, but the decisive basis for determining the protected scope of the European patent. So not a mere guideline to the scope, to assessing the scope. And I read it as primacy of the claims. I know that some of you don't agree on that, but it's there, it's in the decision. And since it is the decisive basis, it is the most important thing in a patent application. This is the way I read the decision. Coming now to the decision of the first instance I was mentioning, I would like to see whether there are some hints to the application of the problem solution approach, which is not compulsory and has not been decided by the Court of Appeal, but will be eventually. The assessment of inventive steps starts from a realistic starting point in the prior art. There can be several realistic starting points. As you know, during prosecution at the EPO, there can be only the closest prior art. But this is not the usual approach of the Boards of Appeal. And so what is said in this decision is standard practice for the Boards of Appeal. The skilled person should have motivation, and also this is standard practice in the Board of Appeal. And the technical effects from different feature may be an indication of inventive step, which comes unsurprisingly. Concerning the objective technical problem, it can be deduced from the patent description as a whole. I was told that this is not exactly the case in the German system. I'm not an expert of the German system, but this may be something to assess. Of course, I would say that assessing the German approach to inventive step should be proposed by the parties, because we cannot go beyond what the parties ask. So try it if you want. I personally would take that into consideration and try to work out each and every approach you may use, waiting for the Board of Appeal to, for the Court of Appeal to decide. Concerning motivation here, it says that the claim solution is obvious if the skilled person would be motivated to consider the claimed solution and would implement it as a next step in developing prior art. And you also have to consider a possible hindrance to this next step. Here it's really standard practice of the Board of Appeal, but this next step is new language. Frankly speaking, I don't attach very much meaning to this next step. It seems to me just implicit, inherent in the process of technological advancement. So it's technological advancement. Why filing a patent if you don't think that it's an advance over the prior art? So it's for me, it's only a question of drafting in English the guidance, but I don't see any special meaning here. Concerning the Bundesgerichtshof, we have the same, as far as I can understand, but there's also the specification that an arbitrary mosaic-like composition of feature is generally regarded as obvious to the skilled person. It's a different wording, so it may lead to different results, but I think once we have the motivation, then of course it kind of implicit that a mosaic-like composition should not be granted an inventive step, but here again it's my opinion. And concerning the could-would approach, we have no express reference to could-would approach as such, but we have this passage in the decision that it is sufficient and also necessary for the inventive step that the skilled person would, without inventing contribution, arrive at the result which is covered by the claim. So we have just a hint to the could-would, but we look forward to seeing new case law on that. So now, interpretation and referral. It would be really improper for me in this framework to say anything about the result of the referral, what should it look like, but I would like to give some food for thoughts to make you reflect on the problems, so without any conclusion. And I devised two examples, similar examples, totally invented, okay? Because I was speaking about the referral with a colleague, and he told me, okay, what if you have cards in a claim, and in the description you have cards including planes? And normal people would exclaim, oh, seriously? But we are not normal people, we are patent experts. And therefore we should exclaim, oh, very interesting. What would I respond to this in a practical case? I don't know, if there is only this. If there is only one definition here, it would be really tough to assess the case and to say that the scope should be extended to planes. So, in my opinion still, it is not very convenient for the applicants to throw definitions without context into the description. Rather, they should give context for us to assess the intention thoroughly. Okay, let's say that we have another sentence in the description version 1, that the method, it is a method, applies to vehicle crossing areas of an airport where cars or planes move on wheels from point A to point B. So, in this case, there is more context. It's not a big context, but it's something more. So it makes more sense to include planes into the cars definition. However, we should also balance the interests, and since the claims are expressing the intention of the applicant, we should ask why didn't they say wheeled vehicles, to say both cars and planes. But still, having this as a hint from the description is very important. So please put as much context as you can in the description. Then we have a different variation of this example. And we have cars running on a highway, which is also very counterintuitive. It doesn't happen. Sorry, planes. There's cars running on a highway. This happens, of course, but there is cars including planes, and the combination of the two is quite unusual and even scary. Again, here it would be even tougher than in the other example to decide, because this is not the normal meaning that it is attached in the common general knowledge in the field. But let's say that we have a description version 2, and the system applies to cars as well as to flying cars, which can run on wheels on highways like normal cars, which is actually the definition you can find over the internet, because there are prototypes. And a very futuristic example, but still, if there is a flying car, it's during the function on highways, it's a car. So it is the applicant is better placed here. Of course, we have always to wonder why didn't he speak about wheeled vehicles, but context help a lot in assessing a case. So what are the takeaways from these examples? The interpretation must be done from the point of view of the skilled person. This is very important. This is how I intend the thing. The skilled person is a sensible person that can only evaluate features in context. So without context, just having a definition thrown into the description would be very, very hard. And of course, finding balance is a skill of judges. But balance is not just the middle point between two theoretical extremes, which are fixed. Is always between extremes which are not fixed, and they are context dependent. And so balance shifts depending on the context provided. This is to say that as much as we can have good guidance from the Court of Appeal, we will never have, in my opinion, a mathematical formula to interpret each and every claim and each and every patent. So it'll be always the task of the TQJ together with the other members of the panel to interpret technical terms and finally decide on revocation and or infringement. Thank you very much.
Thank you very much, Andrea. As you mentioned correctly, there's some overlap with what I'm going to present. But that has two advantages. We can skip something, which is the same, or we can discuss it from two different points of view. So that was a very interesting insight. Thank you very much. And now I would say we would have time for 2 or 3 questions to the gentlemen. Maybe you first. Could you take the microphone, that also the online participants can properly hear you? Thank you.
Thank you very much. So I don't want to disrupt with your presentation after, but you talk about objective technical problem in the decisions of the UPC. Yeah, I think you cited the Amgen revocation case, UPC 1. I may be wrong, but I think they just talk about underlying problem, not objective technical problem. So for me, it's not exactly the same, because it's more, as far as I understand it, more the subjective technical problem, the problem of the patent, and not the objective technical problem. So my question is whether you think my understanding is correct or not, and whether you think that the UPC would perhaps shift in a way like more a EPO practice to the assessment of the objective technical problem, which is, as far as I know, not the case already.
Yes, I was just listing maybe incorrectly. I mean, in the form, the points which are close to the problem solution approach, and this is a hint to the problem solution approach. So we see something about the technical problem. You are perfectly right on the specific decision. From my point of view, it would be desirable to have wide superposition between the UPC and the EPO on the assessment of inventive step. But of course, it's up to the different panels to propose solutions, and then to the Court of Appeal to decide, to finally decide it. That's it.
You might not be the right addressee, but when I look at Article 9.1 of the UPC agreement, panels of the Court of Appeal are composed by 3 legally qualified members and 2 technically qualified members. Why is it that there are decisions of the Court of Appeal only taken by 3 legally qualified judges?
I don't think it's a question for me, of course, but I can only say that in the decision setting these guidelines, they say that it's not an exhaustive list, but maybe it's for more important people to respond if they want.
Yes, slightly different. I'm sorry, you said only 3 legal judges, so you would wish to have more legal judges?
No, more.
No, to have the full composition with 3 plus 2. But we have now decisions of the Court of Appeal with only 3 legally qualified judges.
But only on legal matters.
Yeah, sorry, where is it said in Article 9? Sorry, VCLT plays a role. Article 31, VCLT, is extremely clear. You don't need interpretation. Why is it limited to legally qualified matters, to legal matters? Sorry, a panel of the UPC of the Court of Appeal consists of 5 judges. First sentence of Article 9.1.
So I have a slightly different question. I'm afraid I'm switching themes. On the conflicts of interest point, I understand the point about competitors, etc. How, in practice, has the kind of positional conflict been treated? And what I mean by that is, say, in the life sciences industry, many people would work either for originators or for generics. In telecoms, they might work for SCP owners or implementers. How has that kind of positional conflict being dealt with in practice in the court, if I may ask that?
I don't.
May I ask a question in line with this? I wanted to ask you, in general, you said it's complicated, it takes some time. To what extent the conflict of interest check is slow down the procedures? 2 questions in one.
I start from the last one. It's no. In my case, it didn't slow it down because I was quick enough. Let's say I put a lot of efforts in that case. So I think that also my colleagues would do the same. Concerning the competitors, this is an issue, but. As soon as I look for the 10 first competitors and after allocation the parties do not object, I'm quite comfortable with my role.
And I would like to give you my personal summary of what I read in decisions and also in the law. I will go a little bit faster over some of the slides which have already been covered by other speakers beforehand. In principle, material patent law, as I would like to discuss it today, is claim construction, assessment of inventive step, and a little bit about scope of protection in the context of the limited number of decisions which we already know today. So the first point is the legal basis. Edouard has already elaborated very precisely the sources of law which are involved in the UPC proceedings. I just would like to point out some points which came to my attention. The first point is about direct infringement, which is ruled by Article 25 of the UPCA. It is formulated as a right to prohibit things to other parties, the right to prevent others from making, offering, placing on the market, using, importing or storing products, using processes or offering processes. What is lacking in Article 25 in comparison with German law, paragraph 9 of the patent law Germany, is there's no positive right of use, which we do have in the German law, probably in other pieces of law also. I must admit that this is not very typical situation that you have a positive right to use your patent, but there are these kind of cases. There's a nice decision from the Federal Court of Justice in Germany, Bundesgerichtshof, Trägerplatte, where you find situations where you really have a positive right to use of a patent. That's apparently not intended in the UPC to be included. Also looking to Article 26 about indirect infringement, or sometimes also called contributory patent infringement, maybe more lively way of explaining it in a few words. So delivering essential elements to someone else who then uses the invention. Here I also see one, at least in the wording, one difference to the German law. It's paragraph 10 of the German patent law. We have here the requirement that the person supplying or offering to supply these means relating to an essential element of the invention, they must do it within the territory of the contracting member states in which the patent has effect. So here we have a territorial requirement in the law for indirect infringement. But we don't have it for the putting into effect of the invention based on these supplied essential elements. It's not, at least not included literally in the legal term, contrary to German law, where we have this double territory requirement, and it's now up to the case law to come to a conclusion whether the UPC has a different approach or also requires these double territorial requirement, and I will come to back to this later. One point to which the Court of Appeal refers when speaking about claim construction concerning determination of scope of protection is, and also concerning validity, is Article 69 of the EPC. Sorry, I'm one page too far. Clearly saying that the extension of the protection is determined by the claims, and description and drawings are used to interpret. And very important, we have also this protocol on the interpretation of Article 69 saying how you should not do it from two, so to say, limits. You should not limit yourself to the strict literal meaning of the claims and use description and drawings only for resolving ambiguity. That's what you should not do. But you should also not consider the claims only as a guideline and include in the scope of protection everything what description and drawings disclose. It should be less than that. That's what we had in Germany in the 70s, the so-called allgemeiner Erfindungsgedanken, where you went to the patent and said, what is the invention? And then it was checked whether the allegedly infringing product met this idea of the invention. You should not do that. That's what Article 1 of this protocol of interpretation clearly says. And it should be construed between these two extremes to provide fair protection for the patent proprietor and legal certainty. So that's what the protocol of Article 69 says, and in addition, equivalence should also be covered. Now, the Court of Appeal, as I already mentioned, refers specifically to this Article 69. For that reason, I wanted to briefly summarize it. Yes, and maybe I go back one slide. We also heard that for validity, we have in the UPCA the requirement that a revocation of the patent can only be done due to the grounds referred in Article 138.1 and 139.2 of the EPC, and that's lack of patentability, insufficiency of disclosure, extension beyond the content as filed, extending scope of protection post-grant, non-entitlement, and national prior rights, i.e. national patent applications, are also mentioned in Article 139. So that is the legal framework on the basis of which the UPC courts should now rule about material patent law. And in view of this, I would like to start with claim construction. Advantageously, we already have two very early decisions by the Court of Appeal in preliminary injunction cases. For that reason, we already have these decisions at hand. The first one is the nanostring against 10x Genomics case. The second one, Fusion Group against Henshaw. And already after approximately half a year after the UPC started, we really got, by this first decision, this nanostring decision, really clear guidance by the Court of Appeal how they want claims to be construed in the framework of the UPC. As already mentioned, they refer to Article 69 of the EPC and its protocol. So apparently that's for them a decisive basis. And then they say in the first head note, a claim is not only the starting point, but the decisive basis for determining the scope of protection. So that's the primacy of the claim. The interpretation of the claim should not depend solely on the strict literal meaning. Description of the drawings must always be used as explanatory aids for the interpretation and not only to resolve an ambiguous. And in my opinion, this wording must always is a quite strong wording, which really requires the courts not to interpret claims completely without description and drawings. But it's also clarified that this does not mean that the patent claim serves only as a guideline and the subject matter may extend to what the description and the drawings disclose additionally. That's also very similar to the language of the protocol concerning Article 69 of the EPC. So my personal conclusions from this very important decision of the Court of Appeal are description and drawings must always be used for claim construction. So it's not possible that a court says, at least when following this head note, no, the claim is clear, I don't need description and drawing at all. And now the question is, what are the consequences of this must always language? Does this also mean that the claim construction can go so far that the description can really lead to a different understanding than the wording of the claim alone? So when you read the claim, you have a certain impression, but after you have read the description, you come to a completely different conclusion. That's, by the way, what the German Federal Court of Justice did in the quite famous Spannschraube decision, where you had in the claim the term inserting a certain element, And if you read the description, it was very clear that inserting means only slidably inserting and not pivotally inserting. And the other interpretation was then excluded by the court. Since the chairman of the Court of Appeal is a former judge from the Federal Court of Justice, it's the question whether these kind of considerations will also be considered by the Court of Appeal. We will see. Even more extreme is, by the way, the decision Rotor Elemente from the Federal Patent Court here. I think there was some error in the claim, some clerical error, and the description clarified it. And then the claim was interpreted as the description explains it, quite contrary to the claim language. And even that was a consequence of the fact that description and drawings must always be used for claim interpretation, as it has been done by the German courts for many decades. It's also emphasized in this Court of Appeal decision that the claim is to be interpreted from the point of view of a person skilled in the art, which is quite clear for any person working in the patent field, that you always have to look on the claim from the perspective of a skilled person. And anyways, it's quite interesting how far this goes, at least in this first decision. Because in this decision, there was the second one, the Henshaw decision. Here, it was ruled that, of course, the skilled person uses her or his common general knowledge. And in this case, this common general knowledge was documented by a scientific overview article, which quite specifically taught that it's known to skilled persons that there is a problem if metal parts of a printed circuit board are located close to an antenna. And that not only a shielding effect occurs, but also a quite complex detuning effect. And from this external evidence, the Court of Appeal concluded that the skilled person knowing this would interpret a certain claim feature, which was decisive here, this claim feature 8.4, in a very limiting way due to externally documented common general knowledge. So that's something which I have not seen in this intensity in many cases, I must say. And then probably the most important of the headnotes, in my opinion, is this one. These principles for the interpretation of a patent claim apply equally to the assessment of the infringement and the validity of a European patent. Meaning, even when assessing patentability, or more generally validity, because validity is all what we have in Article 138 EPC, the court must always, that was the terminology, consider description and drawings. That is what the German Bundesgerichtshof consistently does, but it deviates significantly from what the EPO and the Boards of Appeal do. Now, justifying this first sentence, I found it quite interesting that the Court of Appeal then gives some kind of explanation, saying this follows from the function of the patent claims which define the scope of protection of the patent under Article 69 EPC, taking into account the conditions for patentability under Article 52 to 57 EPC. And that is a citation from G2 from 88. The enlarged Board of Appeal decision dealing with the question whether a non-medical effect can establish novelty. So for me, this sounded a little bit that the Court of Appeal wanted to express this in a way that is possibly also acceptable for the EPO and the enlarged Board of Appeal. But that's of course only an interpretation. However, since we have this pending referral G1 from 24, which was already cited earlier today, where the enlarged board is asked to answer the question whether exactly this question, whether description and drawings should be considered for interpreting a claim for assessing patentability, is of course a very interesting case where we will see whether the UPC and the EPO proceedings, to which degree they will be harmonized or not. Yeah, because up to now, the practice of the boards of appeal, the practice has not been 100% consistent in my understanding, but it's quite nicely summarized in the case law book of the boards of appeal, of the case law of the boards of appeal. The description can be used as a patent's dictionary to assess the correct meaning of ambiguous terms used in claims. However, if a term used in a claim has a clear technical meaning, the description cannot be used to interpret such a claim, such a term in a different way. So, if you would have the Spannschraube situation, which I explained beforehand, the boards of appeal following this standard would not consider that pivotingly inserting is not inserting in the meaning of the claim, because inserting seems to be a clear legal term. Yeah, and that will be very interesting how this referral here will be decided and how the case law in the UPC in this context will continue. The second case decided by the Court of Appeal, as I already mentioned, cited again these rules for claim construction, which I presented up to now, and included a further head note saying claim features must always be interpreted in the light of the claim as a whole. And what this means can be derived or can be seen quite nicely in this case. We had again this decisive feature 8.4 saying that an antenna of the radio frequency device being disposed on or in the housing on the side of the front side of an electronic label. And what the court did was they said we cannot read this claim in isolation. We need to combine it with the other claim features, plus what we learned from the description, plus what the skilled person knows from her or his common general knowledge, and then we come to the conclusion that feature 8.4 needs to be construed much more narrow than its literal formulation. So that's apparently what they mean when they say that the claim features must always be interpreted in the light of the claim as a whole. Yeah, so those are the two, in my opinion, most important decisions which we already have at hand from the Court of Appeal. And then there are several other decisions. One, I think it was the first decision from the court, from the Central Division Munich, at least. Also mentioning these rules for claim construction and providing some additional guidance, for instance, again saying here that a patent is its own lexicon. Yeah, and that's more or less what we know presently about how the UPC courts intend to construe claim features. Now, the next question is, which consequences does this have for the assessment of, in particular, inventive step? First of all, what concerns novelty, only a very brief note concerning this, because that's nothing, in my opinion, nothing special. What they do is they first construe the claim based on the description, then summarize the relevant content of the prior art independently from looking to the claim, to not lose context and not come under the risk that certain passages are cherry-picked and then give the wrong impression of what the prior art really teaches. And then, after having done these two steps, checking whether each and every feature is disclosed in the prior art for assessing novelty. It was the local division Düsseldorf ruling in this first court of first instance decision in German language that the assessment of novelty should be conducted based on what the enlarged Board of Appeal of the EPO calls the gold standard, i.e. directly and unambiguously. And now we come to the question, how is inventive step assessed before the UPC? Is the EPO practice adapted or applied? Are practices from the contacting states applied? Or is there the development of an autonomous method for assessing inventive step by the courts? At present, we cannot really answer that question, but we get some guidance from the first decisions, and I will try to summarize it. Of course, one natural way of assessing inventive step in this European UPC system would be to apply the approach of the EPO, the problem and solution approach, selecting a closest prior art document which is the best springboard to the invention, formulating the differences between claim and closest prior art, deriving the technical effects only from said differences, that's important, and then assessing whether a skilled person having the closest prior art at hand and asking herself or himself to solve this objective technical problem, i.e. To modify the closest prior art to achieve these technical effects. That's in principle the way the EPO and the Boards of Appeal do it. In France, as far as I know, please correct me if we have French specialists, they seem to apply something similar as a problem and solution approach, with the particularity that the skilled person and the general technical knowledge is of high importance, maybe of higher importance than before the EPO. In Germany, the approach is a different one. The Federal Court of Justice has always said there's no closest prior art. You need to give a justification from which prior art document you start. You're not 100% free, but if it's a plausible starting point, that's fine. And then the decisive requirement is the so-called Anlass. So there must be a clear motivation for the skilled person to do a modification. The skilled person, according to German practice, does not do something simply because he or she does it. There must be an Anlass, there must be a motivation. And looking what the Court of Appeal did in the only of the two cases where inventive step was assessed, they started with these 6 would have been of interest to a skilled person in the art who at the priority date of the patent issue was seeking to develop a certain thing. So there was no determination of a closest prior art, but the relevant criterion was that a certain prior art document, D6 here, would be of interest to the skilled person. So in the first step, a starting point of prior art has been identified, which would have been of interest to a person skilled in the art. And then it was checked whether there is an incentive or confirmation for thinking in the direction of a need which was derived from the patent. So they looked in the patent, said there's a need to improve something, and then they also confirmed that there was an incentive or confirmation for thinking in the direction to fulfill this need. And this incentive or confirmation is then in an attempt to look for the next step, and Andrea also mentioned this. This is new language in the context of assessing inventive step, at least for me. So that is the second step which they are conducting. And as a third step, they make a cross-check whether there is a lack of reasonable expectation of success. If there are, for instance, significant technical problems involved, then that would be an indication for the presence of an inventive step, that the skilled person would not do the next step in the direction of the invention of the patent. But the court says if these are usually problems with which a skilled person can deal at the priority date, then this is no argument that this justifies the inventive step. So that is what they have done in this first decision, these 3 steps which I just mentioned. The problem and solution approach was neither applied by the Court of Appeal nor was it criticized. They, however, do not use the term closest prior art, but consider sufficient any starting piece of prior art which would have been of interest to the skilled person. And the problem is derived from the need mentioned in the patent and not only from the differentiating features as the EPO does with the problem and solution approach. So to me, that sounds a little bit closer to the German practice than to the problem and solution approach. But that's only the first decision, and maybe that was also not a case where it was appropriate, where they felt it appropriate to really follow one of the known approaches of assessing inventive step very clearly. Then there are further decisions, not from the Court of Appeal, but from the courts of first instance, which of course confirm this. We have here a decision from the Central Division of Munich saying closest prior art is not necessary. Apart from this, it's quite similar to what the Court of Appeal did. This decision of the local division Düsseldorf is very concise concerning assessment of inventive step. They simply cite a commentary of the EPC, but they do not cite case law of a Board of Appeal, although there is plenty. And then they do an argumentation which sounds more German than European to me. Or one might say, when assessing inventive step, they check the subjective technical problem and not the, so the subjective technical problem is what you find in the patent, what the drafter of the patent included there, and not the objective technical problem in accordance with the problem and solution approach, which is only linked to the differentiating features. From the local division of Paris, there's this decision which is more similar to the problem and solution approach without clearly saying this. And this decision from the local division Hamburg, in which also I was involved, this court did something nice. They, there was a presentation by the parties in the framework of the problem and solution approach, but also in accordance with this Anlass case law from Germany. And they said, well, we carried out the problem and solution approach, and we also checked the German Anlass approach, and both led us to the same result. So they did not make a decision which argumentation scheme to be used. They applied what the parties presented and drew their conclusions apparently. And that's probably quite close to what Andrea explained to us. If the parties present something, then the court will probably deal with it, at least consider it. So that's more or less what I have found concerning inventive step with the presently available case law. Now some brief comments concerning scope of protection. The first point is there prosecution history estoppel in the framework of the UPC? Prosecution history estoppel means prosecution history is describes the proceedings between the applicant and the patent office from filing to grant, and sometimes also after grant. Does this have an impact on the determination of scope of protection? Or, as the German courts, for instance, tend, is the scope of protection only derived from the patent in the granted form without too much looking into the, or at least without too much looking into the prosecution history? And here, the decision of the Court of First Instance of this Henshaw decision, which I mentioned, which was then later decided by the Board of Appeal. Here, the Munich local division said in the head note, the original version of a European patents claim may be used as an aid for interpretation in connection with amendments to the wording of the granted claim made during examination proceedings. So they compared the originally filed claim with the granted claim and used this for construing the scope of protection, in this case for quite narrowly interpreting this feature 8.4, which I mentioned already aforehand. So that was really, for me, quite interesting that the the Munich local division mentioned this in one of their first decisions. And then the case came to the Court of Appeal. And they said, well, we interpret feature 8.4 using the claim language, the description, the common general knowledge, and then we come to a good conclusion. If we look to the file wrapper, to the prosecution history, this does not shed any new light on this interpretation in this case. So the Court of Appeal in this case does not need to address the question whether the prosecution history can be taken into account when determining the scope of protection of a European patent. So they left it expressly open whether there is prosecution history estoppel before the UPC or not. And it will be very interesting to see whether we will get further guidance by the next decisions on this legally quite interesting point. Yeah, this I would skip because we have another presentation on this later. Here, a decision from the local division of Munich in German language. That was quite an interesting case. Philips was the plaintiff, and it was an SCP, but there was no friend defense for some reasons which are not really, for me at least, understandable from the file. There was another proceedings in Düsseldorf. Maybe it has to do with this. Probably there was a lack of market power, and therefore this standard related patent was decided without friend discussions. And interestingly, the claim required, it was a telecommunication patent, or it is a telecommunication patent, that an entity, a communication device, accepts or rejects a method. And in the accused product, which worked according to the standard, there was no step of determining whether a message should be accepted or rejected. The message, according to the standard, is always accepted. And then there was the question, does this infringe the claim? Does this fall under the claim? Because no selection between accept or reject is made here. And what the court said was, well, we have to look in the description. If the description mentions this possibility, then it could be covered. But then it's still necessary that this possibility is also reflected in the claim language. And they found in the description a basis where it is said this acknowledgement procedure of accepting or rejecting is optional. So that was for them the point to say, yes, that possibility that there's always an accept message is covered by the description. And they also said, well, you can also derive it from the claim language because that is an alternative, this or. So they concluded that this claim is infringed, but still mentioned that the rule of the primacy of the claim, of course, has to be respected. Now, very strange case, I would say, very specific situation, both from the friend point of view and also from the point of view of claim construction. This decision from the local division of Düsseldorf deals with the indirect infringement and with the question, what are means which are essential for the invention? Because only supplying means which are essential for the invention fall under this indirect infringement, not, for instance, staple goods. And what they said is a claim feature generally constitutes such means relating to an essential element of that invention. So if the feature is in a claim, then you can conclude that this is an essential element of the invention. And that's more or less what has been decided in the decision Flügelradzähler by the Federal Patent Court about 10 or 15 years back, I guess. And second point, they decided exactly what I discussed at the beginning. The court says, yes, there is a double territoriality requirement of indirect infringement, not only in relation to the supplying or offerings to supply, which must occur within the territory of the contracting member states. That's clearly in the Article 26. But also for the intention for putting that invention into effect, also here there must be a relation to the territory of the contracting state according to the opinion of the court. think we can skip this one because that was very specific. And that means that I'm at the end of my presentation. And of course, I'm happy to answer any questions. Daniel?
This one works. Okay. The problem is one thing which is very much forgotten when it is said, also by the Court of Appeal, it should be judged the same time for validity and infringement. The problem is, when the EPC was created, there was a clear dichotomy between what happened up to grant and afterwards. Because we should not forget that the EPC is actually what came out of the 4 drafts for a community patent. And they never agreed. And it was only with the PCT which forced Europe to react. And lots of contracting states did not want to be inundated by unexamined patents. So that is also one of the big difficulties with G124, because they try to unify both concepts, whereas when you look at the intention of the legislator for the EPC, he said, we look at we have Article 69, and that's why they needed the protocol. Mm-hmm. So that is something which, a historical view, which is very often forgotten. Just wanted to make that comment.
Okay. Thank you very much for this comment.
Under the sun. But then if you ship to the rules of procedure, Rule 171 provides that there's an offer of evidence from the party. So a party making a statement that is contested or likely to be contested by the other party shall indicate the means of evidence to prove it. And in case of failure to indicate those means regarding a contested fact, so once the fact is contested, it's only if the fact is contested and you don't submit evidence to counter that the court will take your failure into consideration. And a statement of fact that is not specifically contested is held to be true. So in other words, before the UPC, when you assert something, you bring the evidence that you deem sufficient. The other party doesn't contest it, then it's deemed to be true. So as a defendant, you'd better watch out. And if you disagree with something, you'd better say it, because the court will not take it into account if you don't raise your hand. Then there's a duty to produce evidence. Evidence available to a party regarding a statement of fact, once again, that is contested or likely to be contested. It's very difficult to say what is likely to be contested, but at the very least, you need to bear that in mind, where that party must produce the evidence to substantiate the statement. And the court may, on top of that, at any time during the proceedings, order a party that makes a statement of fact to produce evidence that is in the control of the party, once again to substantiate this fact. And it's only if the party fails to submit this evidence that the court will take it into account. And the fact that the court may order a party to submit an evidence is taken into consideration throughout the proceedings, including in PI proceedings, and we'll see it later. So this is how the burden of proof works before the UPC, irrespective of whether you're facing a case on the merits or a PI procedure. Then, what evidence do you need to bring when you're facing a PI, when you're launching a PI, more specifically? First of all, PIs are regulated by the UPC agreement. Article 62 provides that a party can seek an injunction against an alleged infringer against an intended to which is intended to prevent an imminent infringement, or that is intended to prohibit on a provisional basis the continuation of the infringement. The UPC agreement further provides that the court shall have discretion to weigh up the interests of the parties. And this is obviously where a lot of debate will take place. And finally, point 4 of Article 62 provides that the court may, in respect of the measures referred above, once again, you'll see, require the applicant to provide reasonable evidence. Reasonable evidence. And I weigh my words. In order to satisfy itself with a sufficient degree of certainty. So a party must provide reasonable evidence which will bring the court with a certain degree of certainty that the right holder is entitled and the patent is infringed. So these are the criteria that are provided by the UPC agreement. These criteria, you will find them as well in the rules of procedure, but there's various articles in the rules of procedure that you need to play with, both with the UPC agreement. So in exercising its discretion, the court shall in particular take into account whether the patent has survived opposition, whether it has been subject to proceedings in any other court. It will also take into account the urgency of the action. It will take into account whether the application has been filed ex parte with the right reason to do so, and whether a protective letter has been filed. Rule 211 is, for me, the best summary of what you need to bring when you file a PI case. In Rule 211, you find that the plaintiff must bring reasonable evidence to bring a sufficient degree of certainty to the court that the applicant A is entitled to bring the case, that B, the patent is valid, C, that there's an infringement, or at least that the infringement is imminent. Then it provides that in taking its decision, the court shall use its discretion to weigh up the interests of the parties. Fourth criteria. And fifth criteria, the court shall have regard to any unreasonable delay. So if you followed me, you can summarize the 5 elements, the 5 criteria that the court will take into consideration when deciding on a PI case. Entitlement to bring an action, infringement with sufficient certainty, the patent is sufficiently not invalid. I'll come back to it. That there's an urgency, and it will weigh the interest of the parties before granting an injunction in PI proceedings. Then if you ship to ex parte proceedings, because we all know that PIs are available both inter partes and ex parte. Obviously, when you go to the court and you ask for an injunction without the other party being heard, you'd better have a very solid case and you need to bring extra evidence. So there's extra criteria that are provided by the law, by the agreement and the rules of procedure. So Article 66, now we say UPCA, so I'll go with UPCA because it's shorter than UPC agreement if you're okay with that. So the Article 60 of UPCA provides that the measure shall be ordered without the other party being present. In particular, so not only, but in particular, where any delay is likely to cause irreparable harm to the proprietor of the patent, or where there is a demonstration of a risk of evidence being destroyed. So here you see that the other 2 extra criteria that can justify that an injunction is granted ex parte are A, is there a risk of irreparable harm, and B, a risk of the evidence being destroyed. Then if you ship to the rules of procedure, what do they tell us? They remind the 2 criteria that I just quoted: irreparable harm, risk of an evidence being destroyed or ceasing to be available. It will also take into consideration the prior correspondence that have taken place between the parties, both from the plaintiff and from the defendant, as we will see later. And then one key point with which we're very familiar, I mean, the French practitioners that are in the room are extremely familiar with that, is that when you go ex parte to a court and you ask the court to grant an injunction or whatever measure, as a matter of fact, against a party that is not present, you have a duty of transparency. You need to tell the court everything that the court needs to know to grant an injunction or not. So this is laid down by Article 206 of the Rules of Procedure. So the applicant shall be under a duty to disclose any material fact known to it which might influence the court in deciding whether to make an order without hearing the defendant, including, so not exclusively, including pending proceedings and or any unsuccessful attempt in the past to obtain provisional measures in respect of the patent. So this is the duty that is on the plaintiff's shoulders. And then Rule 212 of the Rules of Procedure remind again the two criteria that I mentioned earlier. So if we summarize, if you're in ex parte proceedings, you need to bring evidence that you would face an irreparable harm as a plaintiff in an injunction was not granted ex parte, that the evidence would risk to be destroyed or to disappear, or at the very least not to be available anymore. You need to provide prior correspondence that have taken place to the court. And more importantly, you need to tell the court everything that you know that could possibly influence the court in its decision. So now, one can wonder, is there a specific burden of proof in PI proceedings? I reminded you the rules that apply before the UPC. I reminded you the criteria that you need to fulfill to obtain a PI, whether inter partes or ex parte. Now, is the burden of proof any different than when you're in proceedings on the merits? Well, luckily, we now have two decisions from the Court of Appeals that set the tone and that give us what we should follow. As a matter of fact, the very last decision from the Court of Appeals was handed down yesterday. The first one was handed in the 10x genomics versus nanostring, and it was handed by the Court of Appeals in its composition with Judge Grabinski as presiding judge. And you can see in this decision, as I think everybody knows, the 10 genomics ruling, but for those that do not know, it was a PI decision that was overturned on appeal. So it was A, one of the first PIs that was granted, and B, it was widely advertised because it was overturned on appeal on the ground that I will comment on later. So what does the Court of Appeal tell us? The Court of Appeal tells us that since the order for provisional measures in issues by way of summary proceedings because they're extremely fast, so you don't have time to do everything, because they're issued in summary proceedings, in which the opportunities for the parties to present facts and evidence are limited. I mean, if you're litigating before the UPC, even on the merits, it's very challenging. So it's a race during a year. So in PI proceedings, it's 10 times worse. So it goes really fast. So the parties don't have that much opportunity to present their briefs and evidence. It's extremely limited. So because of this specificity of the proceedings, the Court of Appeal considered that the standard of proof must not be too high, because it would delay the proceedings and would delay the effect of the PI proceedings. But on the other hand, it must not be too low, because if it's too low, you take the risk that a defendant be injuncted without being properly protected. So we'll find again the balance of interest all in general. So what the court further tells us is that if you look again at the rules and the articles that I mentioned earlier, those rules read in combination provide that the court may invite the applicant to provide reasonable evidence, once again, to satisfy the court to a sufficient degree of certainty. As mentioned earlier, that the patentee is entitled, that the patent is valid, that it is infringed, or that the infringement is imminent. The court follows by saying, such a sufficient degree of certainty requires that the court considers at least more likely than not that the applicant is entitled and infringed. So the criteria is the court considers that it's more likely than not that the patent is infringed. And a sufficient degree of certainty is lacking if the court considers that on balance of probabilities, this is what we're talking about today, balance of probabilities, it is more likely than not that the patent is not valid. And this is what led the court, as you probably all know, to overturn the PI decision, because the court considered that it was more likely than not that the patent would be invalid, contrary to what the Munich local decision had ruled. And so this was back, it sounds like years, but it was only in February 26, 2024. So that was not that long ago. But with the UPC pace, you feel that it was already long ago. But yesterday, we had a second decision from the Court of Appeals that was handed down by the other chamber of the Court of Appeal, which is presided by Rian Kaldin. And Rian Kaldin, in her decision, basically took the exact same approach as the Court of Appeals the Court of Appeals in its previous decision, but just reworded it. So we were talking about more likely than not, and here we're talking about, predominantly probable. So predominantly probable, the criteria, is it predominantly probable that the patent is infringed? Is it predominantly probable that the patent is invalid? So predominantly probable, probability, once again, it's about convincing the judge, convincing the court. So these are the criteria that are used, that have been set by the Court of Appeals on 2 occasions by 2 different chambers. So all in all, people like to speak about statistics. There's not that many decisions, but enough to draw some graphs. So I chose to draw a few graphs and give you some statistics. So within a little more than a year, we've had 18 decisions that have been rendered in PI proceedings. I might be wrong. I'm fairly sure of my data, but you can always miss a decision. But out of those 18 decisions, 2 were following ex parte applications, and 16 were issued from inter partes application. When you look at the success rates, inter partes PIs, 7 were granted, while 9 were dismissed. Slightly more dismissed, but not that much more. And on the other hand, the 2 ex parte PIs that were tried, they were successful, and the last one was successful up to the level of the Court of Appeals. It was an ex parte decision that was rendered. The defendant asked for a review. The review was refused. There was an appeal against the decision of review, and the decision of the Court of Appeal confirmed again yesterday that the injunction was rightly granted. So in terms of statistics of decisions that have been overturned, it's kind of a little bit ridiculous because there hasn't been that many on the other hand. And then if you look at the local divisions, there's a local division that's missing because Paris hasn't heard a PI yet. So be my guest. Go ahead. We need to have some case law for the Paris local division. If you look at the two local divisions that have rendered most decisions, Düsseldorf with 3 PIs granted, 2 dismissed, Munich 4 granted, 2 dismissed, 1 settled, The Hague 2 granted, 1 dismissed, and Vienna, Helsinki, and Hamburg 3 dismissed. Statistics do not mean much, I agree, it all depends on the case, but still, always interesting to have those data. Now, if we go back to the core of what we were discussing earlier, so let's see what illustrations we have from case law on each and every criteria that I quoted. How do courts handle those criteria? So, little refresh of your memory: entitlement, infringement, validity, urgency, weighing of the parties' interests. So if you start with entitlement, so who can bring an action before the UPC? The patent holder, obviously. The exclusive licensee, unless the license agreement provides otherwise. And the non-exclusive licensee can initiate proceedings provided the license agreement allows him to do so, which is new to at least to French practitioners, because this is not the way it is. So all those three parties can, in some circumstances, initiate actions on the merits and PIs before the UPC. In two instances, the defendant has tried to challenge the standing of the plaintiff. As a matter of fact, it was tried twice. It must be that Tangenomics has something about their patent and their entitlement to their patents, because every time it was raised by different parties on different patents, but still it never worked. So in Tangenomics versus Nanostring, the defendants challenged not only the entitlement of the patent holder, but also the entitlement to sue of the licensee. As to the patent holder, they were raising some US law, the breach, which was related to the NIH funding. I won't come into detail. It was extremely complex, but it was that complex that did not convince the court. And as to the licensee, they brought the argument that the licensee could not validly benefit from an exclusive license agreement, and the court said, well, yes, but who cares, because in any event, they're entitled to sue as a non-exclusive licensee. So the arguments were dismissed. And in the other case, Tangenomics, once again, against Curio, different patent, different parties, but still Curio had something to say about the entitlement of the proprietor. They tried to challenge the chain of ownership as from one of the inventors, arguing that one of the inventors of the priority application was actually an employee of a Swedish institute, and that under his employment contract, his right would have been devoluted to this third party. Apparently, the arguments that they brought were not sufficiently substantiated, and they would have needed to bring more evidence to the court that the scope of the patent was related to what it was doing, that the Swedish law would have applied, and what would have been the consequences. So once again, I mean, when you read it like that, it's like, okay, well, they could have brought more, but you need to bear in mind that we're facing PI proceedings that are extremely fast, and it's extremely challenging to gather all this in a very short time period. But still, it didn't work twice. Then if you shift to infringement, I won't go into details into infringement, because there's so many different types of evidence that have been received and looked at by the UPC in PI proceedings. But, I mean, invoices, expert reports, oral testimony, lab analysis. Actually, this decision is interesting. The Syngenta decision from August, sorry. This is where you see that when you litigate before the UPC, you don't have holidays. August doesn't count. There's no traditional holiday. So be prepared not to take any holiday as well. So in this very decision, it was interesting because Syngenta has brought some lab testing results, which were conducted on a product that was actually originating from a third, an external member state. It was not a member state. It was from a different country. And the court looked at the result of the tests, which were once again conducted on the product that was bought or that was available in a different country. And the fact that the plaintiff brought evidence that a product with the same name was offered for sale in contracted member state was sufficient for the court to consider that it was very likely that it was the same product, and that it would be sufficient to grant an injunction. So in that respect, it was quite interesting. And from a practitioner perspective, I must say that the UPC, in terms of evidence, generally speaking, is extremely practical and pragmatic, and parties are rather playing the game. So and it has to do with the rules of procedure that I reminded earlier. If you don't contest something because you don't have anything to say, well, it's deemed to be true, and people actually don't have time to contest every single element that you bring to a case. If you have bought something, you've got a product, you go to the store, you buy the product, you have an invoice for the product, it's valid evidence that the product is on sale. If you're a defendant and you know that your product is being sold in a contracted member state, you don't have time to challenge this, and it's a nonsense, and it's totally inefficient. And this type of defense, to me, has barely any room before the UPC, and even less in PI proceedings. So once again, product orders through a website, this worked as well. In terms of indirect infringement, it would take me a day to go through this, but there's an interesting decision that you can look at, which is the handheld products decision, which was a method claim, and the court considered quite easily that with the videos and the advertisement that the patentee had run, this was sufficient to establish the subjective element of the infringement of and that the intention means was entitled, and it was meant to be used under the claim that was used as a basis of the infringement. The same goes with the manuals and instructions of the defendant's website. This was the Tendernomics decision with her nanostring, so there was no big debate about that. Then, on the other hand, so there has been one very interesting decision for those that are active in the pharma sector, which is the Novartis versus Celltrion decision, which was a PI decision that was rendered in favor of the defendant, who argued with success that there was no evidence of an imminent infringement. As those of you that are familiar with the area, it's not because you obtain an MA. This was not a generic. It was a biosimilar product, and the Celltrion had obtained an MA, and apparently some employees of Celltrion had made some statements vaguely in some fairs and trade shows that they would put their product on the market. But there was no tangible evidence that Celltrion had actually taken positive steps to put its product on the market before the expiry of the patent, such as obtaining reimbursement price and and taking positive statements towards the pricing agencies that are required on a regulatory standpoint. So the UPC here made it clear that A, they would not apply national law, that they would make their own case law, and they looked at all the evidences, and including testimonies from the defendants who positively stated that they would not launch the product until the patent situation had not been sorted out. And it convinced the courts that Celltrion was not about to launch its product, that it would not launch it before the expiry of the patent, or before the patent will be invalidated. So mere allegations from some employees in some places that are contradicted by witness testimonies cast enough doubts in the court's mind that the product would be put on the market before the expiry of the patent. Then when you shift to validity, as you can all imagine, the burden of proof on validity doesn't lie with the plaintiff, but with the defendant. The burden of proof is on the defendant to show that it's more likely than not that the patent would be invalid. And I do not have much time to comment on this, but there must be a strong indication that the patent is invalid, or the UPC will grant the injunction. This is interesting to bear in mind as well. This is constant case law from the Munich local division, what the Munich local division has said in 3 different decisions is that when you're in PI proceedings, as I said, you don't have time. So if you're a defendant, you're sure that the patent is invalid, you have to put your 3 best arguments, and the court would only look at those 3 best arguments. So if you want to multiply your inventive step attacks with 25 combinations of documents, the court will simply not look at them. This is the Munich local division, but once again, it seems to be quite pragmatic given the time that everybody has. Urgency, that's also a very important point. Urgency, there's 2 sides to urgency. There's the temporal and the factual circumstances. This has been reminded in numerous decisions. On the temporal urgency, what I will shift to give you very efficient information. I'll try to be like the UPC. There's 2 different divisions that have 2 different time frame in mind. Düsseldorf imposes a 1-month delay to launch your action as from the day you know about the infringement, while Munich keeps on saying that it's 2 months. So depending on where you go, depending on when you learned about the infringement, choose your division. For the time being, they're sticking to their position. But the key question is not really the 1 month or 2 months, because hopefully you'll do your homework first, is as from when do you know that there is an infringement, and have you done your homework? So I won't go through my slides, and you might have them later, but what you need to bear in mind is that it's on the plaintiff to do its homework from the outset and through each step of the process. And as from the day the plaintiff knows that there's a product that is likely to be infringed, it needs to conduct all the researches, all the analysis to confirm or not that their patent is infringed. And the court will look at it. And there's one decision that I have somewhere, which is from another local division here, the Berliner decision in Hamburg. Hamburg decided that 6 months was way too late, but what was specific here is that the party that knew about the infringement was the predecessor of the patent holder. So there's been an assignment of the patent, and the fact that the predecessor, which was apparently linked to the new patent holder, but the predecessor knew about it, they have had exchanges, and the Hamburg local decision considered that 6 months was way too late. Then obviously there are substantive circumstances that you need to take into account, irreparable harm, whether you're approaching a fair trade, you need to act quickly. These are the types of emergencies that are taken into consideration as well. The weighing of interests here, those that are familiar with German case law will know all about these criteria, but you will look at, is there a possibility of a workaround? Do you have a substitutable product on the market? What is the size of the company? What is going to be the impact both on the plaintiff and on the defendant? If the defendant is struck off the market, what is going to be the consequence for the defendant? And for the plaintiff, is he going to lose the market forever or for at least a long period of time? So if you have a long life product, obviously in the nanostrings decision, this was exactly the case. You buy one of those huge machines, which are extremely complex and extremely expensive. You're not going to buy a new one within the next 2 months. So once the order is placed, it's placed, and the market that you've lost is lost forever. So these are the types of considerations that are taken into account by the courts. So the summary, I will skip that one because I just have to quickly switch to ex parte measures. But the 2 decisions that have been ordered are the Maistromer decision and the Autovox. The Autovox decision, I already commented about it. The Maistromer decision, it was the very first one. I think everybody's heard about it. It was on a trade fair. It was an e-bike that was about to be exposed on a trade fair, and it had to be done on the day. Whereas on Autovox, as a matter of fact, the application was filed right after the trade fair. And even if it was right after the trade fair, it was right before Christmas. And those of you that like skiing and that like cross skiing, they would know that Autovox is this kind of apparel that you wear when you go cross-country ski. Some of them know. And when you buy one of them, they're extremely pricey. Once again, you're not going to change, and all the orders are placed right before Christmas. So this was what justified the PIs that were granted. And I was also asked to refer prior correspondence, whether the plaintiff has written, whether the defendant has written, and if the defendant has written saying basically nothing, the court is going to take it into account. And protective letters, very quickly. What is a protective letter? If there any German person in the room, the Germans, the Dutch, the Belgian, they all know very well what protective letters are. The French, we know very less, but we learn. But basically, when you feel that that a patentee is going to file a PI ex parte against you or seek a seizure against you, you'd better think of filing a protective letter with the UPC to put to the attention to the court your defense arguments, should they be on validity or on entitlement or infringement, what you have to say. The court is going to examine it if an ex parte measure is requested. A protective letter, beware, is not a warranty against the PI. It's not because you filed a protective letter that the PI or the seizure will not be ordered, but it's a way to ensure that at least the court has seen your arguments. How should protective letters be used? Well, protective letters is an art in itself. And it's good to have German colleagues to tell us what the do's and don'ts about protective letters. Because on the one hand, you want to say everything and put all your defense arguments. But on the other hand, you're like, oh, should I save some for later? But if your letter is too empty and the court sees it, it will believe that that's all you had. And then it will grant the injunction. So it's a real art, and there's pros and cons. But if you really fear that an injunction is going to be sought, you'd better file a protective letter. Once again, you can see it from the Maistromer case. In Maistromer, the protective letter was so poor, there was no invalidity argument. They merely alleged that there was an alleged exhaustion defense, which was apparently not very convincing, and a minor infringement defense, and it was definitely not enough to convince the court, quite the contrary. And as a matter of fact, when I'm saying that it's worth filing them in Autovox, the court took into consideration the fact that the defendant had not filed a protective letter, so they had not been very diligent. And last but not least, are protective letters accessible? That's a very big question. By rule, they're not accessible to the public, but the public could possibly ask to have access to them. So when you file a protective letter, you'd better act for protective measures to make sure that they're not accessible to anybody, especially if you have competitors that are also likely to be interested in what you're writing in your letter and what you have to say about your product. And I have open questions. And I don't have the questions that I have at the bottom of my slide are open questions, because I have no answer for the time being. If there's an application for preserving evidence ex parte or PI, I do not know whether the protective letter is directly forwarded to the applicant, or if the applicant is only made aware that there's a protective letter, because we all know that if the applicant is aware that there's a protective letter, he can withdraw his application. But I do not know to what extent he has access to the full protective letter or not. Other questions that I have, in case several protective letters are filed, if you file an application for a PI against one defendant, are all the protective letters coming out, and are you aware of all the other competitors? I do not know. It doesn't. The rules don't say so. And last but not least, I do not know whether protective letters can be withdrawn. You filed a protective letter, at the end of the day, you're not that happy with it. I haven't found any rules that to say that you can withdraw them. You can update them, you can possibly add to them, but I don't know whether it replaces the first one or whether it just complements it. So these were my opening thoughts, and I'm sorry I've been way too long. Thank you very much.
Much. It's great getting the applause before the talk. It's the sure way to go. We're grateful for that. I'll use 1 second to say, please join APEB. It's a great association for patent nerds. We're having good fun. I've seen a few other colleagues from the association here today. Please join us. The other introductory thing I've been asked to say is that everybody on this panel will be sharing their personal views. They may not be those of their organizations, their clients, or anybody else. We've been asked by the organizers, after this extremely full and interesting day going in many aspects of the first year of the UPC, to take a bit of a bird's eye view and take some distance to what's happened. And we'll try to do that. I would have been incapable of doing it. Thankfully, I have an extremely distinguished panel with me. and I'm sure they'll be doing a great job. So maybe, apologies. Looking back at the first year, what has been, in your view, the best and the worst surprise of the first year of the UPC? And I'm going to try to make this question a little bit harder, because I'm going to ask you to not name the CMS as the worst surprise or the best, but that's not going to be hard. As the worst surprise of your experience. Peter, do you want to start?
The worst surprise were computer issues. And the best surprise was learning to work together with international colleagues on the panel.
Thank you. I saw what you did there, right? I mean, do you want to take that as well?
Sure. The best surprise, I think, is to see how well accepted the UPC is. From the number of cases, I personally, I had high hopes and high trust in the court, but seeing so many cases and seeing how the numbers ramp up, that second panels need to be opened and so on. So that was really the best surprise to me. The worst surprise, maybe something that I should have known, but still, when being in it, is the time pressure being put on the parties involved in proceedings. And as I said, it's in the rules, we knew it, but doing it is just a different thing.
Quadra?
Yes, as a surprise, and maybe it's not really a surprise, but as it could be seen beforehand already, a real positive thing is the big enthusiasm of all the judges and the clerks in making this happen and making this work, in spite of the challenges of computers and CMS and everything. It feels sometimes a bit we're all in the same boat, and if there's anything positive about the CMS, it's putting us all in the same boat, so to say, as there's always a positive thing in everything. So I wouldn't really call it a surprise, but I think that's also a key point of the success of the UPC so far, is the commitment of the people behind it. First and foremost, of course, judges and the clerks, but I think also the lawyers. We have our share in that we want to try it, we want to make it work. And I think that's a positive thing. But maybe as the negative side, and maybe there also again are lawyers to blame, is the complexity of it. And that is, even though it was a bit like the deadlines, which I would also name here, it was kind of foreseeable, but yet I think a surprise of how complex it is, because really everything is being challenged, and maybe you have to do it, because if it's not settled case law, you have to represent the interests of your client and you have to challenge everything. But it makes it so complicated. Issues like confidentiality, the discussion about the access to the files, CMS doesn't help, obviously. And I would also add the very tough deadlines. Even if you know they are tough, it's still... at least in the national system so far, even though there were, of course, also the deadlines, there was a bit more room to wiggle. And usually you don't have just one case, but there are a second client or a third client. And we managed, but this is now quite a challenge to deal with the deadlines. And maybe that would also be a bit of a plea for a bit more flexibility there in some cases, even though I know that there's a strong... incentive and a strong will to show we are doing cases within 1 year. But I think between parties and with our colleagues, we would be maybe sometimes more generous with our adversary than the court would be.
Overstepping my role as a moderator for 1 second, to share my own kind of, well, one is a half surprise. The positive is how efficient the court has been indeed. I mean, delivering on its promise. The negative one I would point out, just to name a different one, is I find the issues around service outside the EU to just be a massive burden. And I appreciate it's not one that is legally easy to fix, but it's just such a massive source of inefficiency in a system that otherwise has proven to actually work really well. that, in my ideal world, and everybody can dream of their ideal world, I would try to change something there. I saw you disagree with me?
Nope. Because I'm just asking myself the question, did anything change here? Because the sources of law, the Hague Convention, and also the European regulation, they're identical. And so therefore, maybe for some member states, I think even more for the judges than for the lawyers, it might have changed, because there are some member states which didn't deal with service so far. But from the German perspective, where it's just everyday business as we've done before. Of course, if you have to service in China via the Hague Convention, that's always a tough game. Yeah, but it has been like this all the time. So I don't see any difference in my proceedings when I compare them, the UPC to the national proceedings.
Well, maybe a difference, especially in the beginning, there was some uncertainty of whether you could serve with or without exhibits, and whether they have to be translated and so on. I think that was at least some uncertainty. And I think what increases the complexity is if you assert a patent for various countries within the UPC, you have a multitude of defendants. Previously, you might have the German or the national distribution company and then the non-European mother company. And now you have, for every country, you have a separate entity. And that increases the complexity by far. And also you have to show their involvement and all that. And so it adds further layers.
And that adds, of course, when it's served, when the different timelines run, which also makes it a bit complicated. And also from a user, you get one reply, but you don't know what the other will answer, and then you cannot consider all the answers before making a reply.
May I comment? Yeah, but here I think you have to see that now you're getting a lot of eggs in one basket. So of course it's more work, but still you get one decision for multiple jurisdictions. And on the other side, what you already pointed out, I think really a bit of a problem is, but maybe that dries out over the time, is that I think many people are acting very nervously these days. And therefore, for example, the question, if you have like 6 defendants and everyone is served at different points of time. In national proceedings, I never had any issue that an agreement is found between the representatives. Okay, let's agree that we take the point of time where the last defendant had been served. And there was one example in my proceedings where I've been asked to prolong the time limits accordingly, and I said, yeah, sure, that's what we've done all the time. And what you receive is a 333 request, review by panel, which of course confirms the judge rapporteur. And so that's a bit what I want to express by saying everyone is a bit nervous at the moment. And of course, we also, as the judges, understand that the lawyers have to play the game. But I'm sure that the Court of Appeal, at least, will very soon dry this out a bit and make life easier for both sides.
And maybe a bit the hope would also be that once we have a new CMS, which would also allow for a bit more alignment, like some type of communication. This is the deadline schedule of 6 defendants. Can we agree among the parties? And then the court issues the respective order, something like that. That's a bit without opening various workflows. So there's a bit of hope that these issues can be handled with more flexible.
I was not expecting to open such a huge debate by referring to this particular problem, but it was a very instructive one. So thanks for the remarks on that. Anna, you referred to acceptance of the system as one of the elements of the positive. More broadly, what do you think about adoption by users? What surprised you? I guess there was an expectation beforehand that pharma in particular would be cautious. There was maybe also an expectation that we would see very many cases by non-practicing entities. Is the picture different in your view? What do you think generally about acceptance of the system?
So maybe to get to your second point first. So did I expect seeing many NPEs? Actually, I did not. So I think the way, so I mean, NPEs we usually know from the US, and the system is very different there. And I think one important difference is for me that in Europe we have the rule that, or for the UPC, that the loser pays. And this is very different from the US, where you can just make a shot. And if you win, nice, and otherwise you just have to pay your own fees. And there is a real industry behind this. So, and therefore I didn't expect that, and I think we don't see it for the NPEs. The other part, the acceptance of the users and what was thought about the industry, what was thought in particular about pharma. Actually, I mean, I'm from a pharma company, but most people know it as Roche as a pharma company, but Roche is also a medtech company, actually, a diagnostics company. But when we look at the pharma figures, I think I read somewhere that I think it was 28% of the A61K classification patents are going for a unitary patent, actually, and mechanical classifications or electronics are below. So there are 20% of the EP patents going for unitary patent, or even 16, I think, for electronics. So that's from the what is currently granted, and from the cases we see. I mean, we do see some pharma cases, and some were mentioned today. Sanofi, Amgen, or the Novartis Genentech case, or there's Astellas, Helios. So there are some pharma cases already, and currently I think there's more other cases, but this is something I did expect. But there is already a decent number, and with the unitary patents granted now, we will see more.
Thank you. Peter, Cordula, any comments on that?
No. Yeah, I think we see a broad spread of technology, of sizes and everything, and I guess it's also too early to, even if there's a bit more of one type than of the other type, it's too early to tell really, and to draw conclusions. Some may be waiting a bit, and also whether you start litigation, it's sometimes a bit arbitrary. So I would say for every 3 to 4 complaints I'm drafting, only one gets filed, because parties settle, different target gets into focus for whatever reasons. So it's a bit, you can't really predict that, and whether there's a bit of focus on one side than on the other side, that doesn't really necessarily tell what the real focus is.
Yeah, so just what I can tell from the cases pending at the local division Mannheim, it's really a broad array of everything. So we got strawberry fences, we got LTE patents, we got medical devices. It's very diverse. So I cannot see that that there's a strong emphasis on a particular sector here.
Thanks. Obviously, when you put 3 lawyers into a room with a set of rules, you're going to have 4 opinions on what those rules mean, right? And so there was a lot of debate on the rules of procedure before the court started to function. And at the time, it was hoped, notably, that the Court of Appeal would quickly intervene to sort out the issues quickly for practitioners, right? I'm going to ask a very long question, and then you can pick which bits you'd like to respond to. The general question is, do you feel it has done so and has done a good job at that? I would maybe comment, again, overstepping my role, to say that I'm slightly under the impression that it has done so very much on procedural matters and has been very careful on substantive matters to wait for more case law to come up from the first instance, maybe, to have more views. I've seen a case recently where the Court of Appeals has said about an argument, this argument is inadmissible because it wasn't raised properly at first instance. Okay, I understand that. Next paragraph. Also, it's wrong, which is, let's put it as unusual, right? So how do you read the way the Court of Appeal does its job in that respect? And what do you think about the way in which this contributes to acceptance of the system? And final bit of the question, what would be the main areas where you would want more guidance? I promised a very long question. I did deliver on that. Cordula, do you want to go first?
Yeah, let me go first. I mean, clearly we have, in the beginning, we have more guidance on procedural issues because the first main decisions have just come out. So you cannot expect an appeal decision. And the appeal decisions kind of on substance we have are on PI proceedings, which is always a different set of different context and maybe different way of discussing something. So it's I think it's fair, and that you need also a certain number of cases in order to really see and develop a body of case law. So at the moment, I would say it's they're working on it and it's doing a good job so far.
Yeah, I think the Board of Appeal can only rule on the cases that are brought to them unless they comment on something in an obiter dictum. So, as Cordula said, it's in particular procedural questions. There's interesting decisions. So, just a recent decision on language. I have to say I didn't quite expect it, a change of language from German into English. That was, or to me, that is an interesting decision in what it tells for the future application or of the future choice of languages. That was an interesting one to me. And yeah, so also, I mean, where I would like to see decisions is or no more. I mean, there was also a decision about a stay of proceedings, that also procedural, of course. But this is something that, as a user, that very much interests me, and that that has an influence on my strategy. But again, the court can only rule on what it is given to, and as a user, it's also. Sometimes, I mean, I'm interested to get the Court of Appeal's view on it, but does it help me in the specific case? Well, that's another question. Or the case might move on anyway, and then concentrate more on other factors. So, in general, I think the Court of Appeal does a good job in the decisions they take and they get. Of course. I think we are all very interested in learning more about how inventive step is approached, and there is some first decisions and some first hints, but of course we are interested to learn more about these questions.
Yeah, it's of course not for me as a CFI judge to comment on the work of the Court of Appeal, but still I will do. The only thing that we also have to take into account is that maybe the Court of Appeal still has needed also this first year to groove into things a bit, because for them it's also a very different setting, and compared to at least the local divisions where you have two national judges, it's quite easier to at least to find a point of convergence. And at the Court of Appeal, everyone has a different nationality, and therefore, if I would be there, I could envisage it not to be very easy in the first days. But that's something where I'm a bit surprised already that that doesn't relate to the Court of Appeal only, that we when we discuss with international colleagues, that we very, very often arrive at a good solution without strong debates on both sides.
And maybe to add, I think it's you get only real clarity with a lot of cases. Like even if you have, for example, on inventive step, you get kind of the lead sentences, or call it problem solution approach, call it whatever. But that's just words. In order to actually understand how a court will adjudicate that, is you need to see how that is filled with life, and then it doesn't help you to just have just one case and that one set of facts, but only after a couple of cases you see how it develops and then you can kind of gain some understanding of how the court might decide that specific case. Also, I think an inventive step is never predictable anyway.
Let me ask you a slightly different question, if I may. I think it's fair to say that the original promise behind the UPC was to create this new system, this patchwork or this Esperanto derived from the best bits from our legal traditions from different countries, right? My question is it really Esperanto we're speaking today, or are we speaking German with a slight foreign accent? And is that a problem, and can we fix it if it is one?
Yeah, I think it's like always with history, you have to look back to understand where you come from. And I think for me, all what happens at the moment is not a surprise. Because if you look back and look at the figures, if you look at the last 10 years before the UPC, you had about 1,000 to 1,200 cases in Europe, out of which 900 were in Germany. And of course, now the clients have their relations with expert law firms in Germany mostly, of course also in other countries. But therefore, for me, it didn't come as a surprise that they at first perhaps had a tendency, because of all the uncertainty in the system, that also the lawyers then would advise clients, perhaps if you want to have some level of security, try it in the German divisions first. Of course, I hope that this will change over the time, but I think it will need some time, and therefore for me in the first year it's absolutely not a surprise that most of the cases went to the German divisions, just because of that reasons. You have long established client lawyer relationships, and why should they decide, oh no, I will change things and go to France, go to Italy, go elsewhere. And that's what I mean with nervousness, because what I, from the judges' bench, see right now is I feel that there's a lot of nervousness in the lawyers' market at the moment.
Yeah, I mean, we are sitting here with three Germans in the panel, so maybe we should ask the audience. I would say yes. I mean, and you always see what you scan for. So if you look, do I see some parallels to German cases when we think about urgency, for example, how many, 1 or 2 months or whatever, these kind of questions. Yeah, this may be German thinking. Today, I also heard decisions where I have to say I do not have that much experience with, but about ceci contrefaçon or inspection. So this is really something that comes from a different system. And then also I can share so that we have a lot of discussions also about what kind of arguments should we bring? Well, in Germany we would say this, but at the EPO we would argue differently. So I wouldn't say it's so German, but I'm maybe biased from my German background.
Yeah, I don't really have much to add there. I think if we talk about file inspections, that's certainly not a German approach that's being done at the moment.
Did you want to add something?
Just one example. I think even if at the moment a lot of cases are pending with the local divisions in Germany, still the handling of the procedures is quite differently. So already in those first proceedings, I've done a lot which I would never have done when applying the German Code of Civil Procedure. And it's really starting, you rethink things, you start not from scratch, of course you have your experience, but it's a different setting. And and I think that is true for everyone. When discussing with the international colleagues, I do not have the feeling that anyone on the judges' bench is trying to press his national understanding into the system.
I would add that maybe to give my opinion again, and then you will contradict me, and that's great. Beyond the question of where the cases are filed, there is also the question on who works on those cases, on both sides, actually, of the room, right? So I find it surprising, we do it at my firm, to put together transnational teams to work on a case. I find that actually super helpful because these rules are transnational and the panels themselves are not just from one country. So I would have thought that would be a more common thing to do, and maybe it would help kind of exchange more experience. And also, we had a conversation yesterday evening over dinner, Peter Tochtermann, where you said that because the German judges are so busy, it's hard for them to get put on as the third judge onto non-German cases. And that also arguably doesn't help the communication and the flow of experiences between the various traditions. Because and this is not a criticism of anybody, right? It's just a direct result of the number of cases filed. But beyond the question of where the cases are filed, I would personally love to see the system function in a slightly more European and slightly less, this is the X division of the UPC located in this country, manner.
Here, I do not disagree. I agree with you. No, but it's really a bit part of the problem. Of course, if many cases are brought to certain divisions and people have to work around all day long to get their work done, of course, then traveling on top is a bit difficult. Still, as Florence will be able to witness, I'm already on overload, but still I said, please assign me to Paris cases in the French language because I want to contribute. And of course, I think this just it's difficult in the setting at the moment because it involves the traveling, and this is certainly a point where you have a valid argument here that in the midterm, long run, we should perhaps even rethink things here. But now we have a bit to live with what the member states gave us in the UPCA. But I agree, it's very difficult. It would have been a completely different setting if the member states had decided to set up the UPC in one court here in Strasbourg, for example, and everyone would chat over a coffee. And we only have the exchanges via internet. We have the exchanges twice a year on our judges' conferences. And of course, when someone flies in, sits on a case, but all that is very different from working in the same building. But still, that is the political outcome of it.
Well, that was my achievement of today, saying something and then hearing that you agree with it. I will take that home. I will probably ask a couple more questions and then give some time to the room to ask questions, especially because we need to stop at 5:30 sharp because some of us have travel commitments. So maybe the first of my final two questions would be the relationship with national patent litigation, which still is a possibility beyond the technicalities of it. Like fundamentally, what do you think about the relationship with national proceedings? Do we still need those? Will we still need those? What's going to happen with them? Cordula, do you want to start on that one?
Yeah, happy to. Yes, I think they are still very important, and I personally even hope that they will be there for good, so to say, because I think the UPC is not the right forum for everything and every case. That there are cases where having a national court or national litigation might make more sense because of the size, because the German market, or be it the French market or wherever it is good enough, and you have a less complex system because it's more straightforward in that sense. So it's easier, and that might be needed by some clients in some cases. So at the moment we're seeing, of course, national litigation, and we're seeing quite a number of litigation campaigns. There's even parallel litigation at the UPC and in national courts. But of course, there will also continue to be purely national litigation, and I think it's a good thing.
Yeah, I think at the moment we work within the rules, and we play within the rules. And at the moment there's a big playing field, and a big field for having certain strategic implications. I mean, where to file, have an opt-out or not, and so that's a very interesting time, I think. And we see this from the decisions also, right, where there is national and UPC proceedings and so on. And I mean, so one example for why national proceedings are still needed, think of a case where there is different ownership, for the parts of an EP patent, and in the future that would not be possible. So, I mean, for the next 7 years we know, or 6 now, and then maybe prolongation, we have these different options, and it's a very interesting time, that's what I can say.
Yes, I personally really do hope that still cases will be brought before the national courts. I think that's also very important. At the end of the day, the UPC is in the full variety of possibilities that you have won. But I think it's also very valuable to discuss with national colleagues, then to exchange. And also for the UPC, for the future development, it will be very important from an HR perspective. We've seen that quite a number of judges now moved to the UPC. And we saw a number of presidents of national courts who were left behind in grief and maybe anger sometimes, I don't know, because they lost very experienced judges. But what is clear is that you do not want to hire first-year lawyers for the UPC. And so in the future, I would love to see if we still have also a certain number in the national courts, which allows the judges to gain that experience and maybe then come to the UPC as young judges in secondments, clerkships for 2 years, something like that. Because I know my colleagues in Mannheim, it is not everybody who's interested in working in the UPC. Some just want to do their national job, and others are more international and find it rewarding to embark on that journey, but not everyone. So I think both paths are very valuable to rendering justice.
Thank you very much. My final question is going to be about one aspect of future developments of the court, and it pertains more particularly to the Patent Mediation and Arbitration Center. So in some countries, some people will think that mediation is used by courts to get rid of cases on their dockets because they want lighter dockets. I assume that's not going to be the case at the UPC. So what is it going to be used for? What is it good for, given the existence of national proceedings, etc.? Can one imagine that UPC judges will mandate mediations in certain cases? And who do you think should be the mediators? Again, very long question. You can pick and choose which bits you want to address.
Yeah. Happy to start. I think it's really good news that the PMAC, the Mediation Arbitration Center, is now being set up. We have the director, and I think work is ongoing on the rules of arbitration and mediation. We occasionally see that mediation and arbitration works between parties. We just had a case actually in Munich, where the Munich mediation solved. Got the parties together, so I think it adds to it, and I think especially in the field of standard essential patents, it can be an additional option. Maybe the court says, okay, now you get together and sit together. Here's my guidance on you. What happens if you don't? And then they go to a mediator, and maybe the case gets solved. So that's always preferable. So I have quite high hopes there.
Yeah, I think it's an interesting option, and from an industry point of view, it's interesting. For example, for contracts, when you cannot agree on the Gerichtsstandort, on the jurisdiction, yeah. So to have that as an option there, I could see it. I think it will also, remain to be seen how accepted it is. But this is a point or an occasion where I could immediately see to use it before an actual dispute happens, but agree on it beforehand. And in terms of who should sit there and be the mediator, that's a difficult question. So again, thinking of it beforehand, when the parties still have a choice on what they want to agree, they may want to have most impartiality, and so maybe have less connection, so to speak, with the court. But on the other hand, I think the UPC already has, and I'm sure it will even have more trust and good expectations by the parties. So I could see that this is an interesting option, that we don't have something similar yet.
Yes, I hope that the center will be used, and I'm quite sure that the judges will be aware of this option and may also perhaps open the doors to mediation, because usually you do not have a contract dispute here, so where possibly you already have an ADR clause and can refer to that, and so one side might have fear to lose face if it even makes the proposals, oh, should we perhaps try mediation, because that can be regarded as a sign of weakness of the position. And therefore I think the judge rapporteur, for example in the interim conference, can then be kind of a door opener, and of course he cannot just order them to go there, but it needs the consent of both sides. And I can envisage two things. Either you can use the interim conference, which is always up on mandate of the panel. So it's not only the opinion of the judge rapporteur alone, but of the whole panel, that you can perhaps make some preliminary legal remarks, and then tell the parties, okay, now you perhaps have a bit of a picture where the journey might go. Take it with you. Let's take a break for a reasonable period, 2-3 months. And see whether it works out at the end of the day. Another option might be that you might even get mediator judges involved. That might be an option. It is not decided whether, for example, one of the judges of the UPC who is not competent to hear the case may be on the roster of mediators. I don't see that much for arbitration, I think, but maybe for mediation. And then in the course of the mediation, if accepted by the parties, the mediator could also give a legal opinion. That's an option. Not everyone accepts it in a mediation, but it's an option at least. And I think this link, and I still think that the PMAC it's close enough to the court, but it's also far enough away. So which might be an option to ICC mediation, to WIPO mediation, whatever mediation you might envisage.
Yeah. And if I may add, I think especially if mediation, for example, is suggested in this interim conference, it could be helpful. I'm always surprised about the huge human factor in cases. So you would assume you have two big corporations and it's only about the money, and you go after your claims or you defend against it. But whether the case is settled many times just comes down on the persons behind it, and whether someone is fed up with it, or whether they get along with each other, or whether there was a bad word and then someone is upset and doesn't want to talk to that person. So it's a lot of human factor between parties, or an employee changed to another corporation and then they're whatever. So it's the whole psychological point, I think, was a surprise to me when I actually started working in law. So maybe that is something a mediator can solve and get the tension out, and then find a solution to that.
Yeah, thanks very much for these insights. You have 10 more minutes of this truly exceptional panel to ask your own questions, which I'm sure are going to be much better than mine. So please go ahead.
We have two questions online. First question: to date, have there been any case involving small and medium-sized businesses before the UPC? If so, could you tell us a little bit more about them?
Well, I can say that the very first case I filed, it was two small or medium-sized companies, two German companies actually, fighting before the UPC and asserting a patent. Then actually even in other countries, Germany was actually not part of the UPC claim, but it was only about other countries. And going to UPC was certainly also because going in all of these other countries one by one would have been much too expensive. So yes, it can also be used by smaller companies, and we've done that.
Also, Mrs. Butin, I don't know whether you have any comments. I'm sorry to call you out, but this is something, maybe you have views on that?
We don't have statistics on that, but what I can just see from my experience dealing with the language change request, it's to some extent part of the arguments regarding fairness for allowing smaller companies to be able to put means in the litigation. And so I would say from just my experience in point of view that we have small and medium-sized enterprise using the UPC. Yes.
So and as an addition to that, I think the statistics that show that SMEs tendentially use the unitary designation more than large companies currently, eventually it's bound to lead them into the UPC, right? So that's an element of response as well, potentially.
There was also a question of cost that has been raised earlier in the day. People were wondering whether or not it would be cost effective, more costly, less costly. Do you have any comment to share in that regard?
It is substantially more costly than doing national proceedings from the lawyer's side, because it involves so much more work. a lot of that goes to the CMS, to be fair. And you can always discuss whether to charge the client or not. But still, because of the things we discussed before and everything being challenged, maybe that changed a bit, but you have the various parties. So you are litigating in various countries in one, so it's okay. And then also the importance of the case usually is bigger because you can lose or win in all countries, so you put more effort into it and looking into every argument. But it's certainly substantially more expensive than doing just one national proceeding.
Yeah, and I mean, for the writs, as you have mentioned, and also there was a comment on it before, or I think you mentioned, I mean, the nervousness. And so as we don't have the case law yet, and don't know whether certain arguments we are completely in vain, we do not need to bring them. Yeah, we do need to bring all of them more or less, because one of them could be the one, and that of course also adds to the costs in the beginning. But for this part, once there is more clarity, then it can be more, maybe the writs can be more streamlined and then reduce costs on that end.
Would you agree with me, though, that even though over time it's expected that, we spend less time litigating procedural issues because they will have been sorted out, right? But still, I find that the time intensiveness of the proceedings is inevitably result in the cost being higher than the same substantive work spent over a longer period of time.
Yeah, just because of the tight deadlines. Some people actually do go on holiday sometimes.
Not in France.
Okay, then you don't have that issue. But you might need more than one lawyer on that case just to cover. And to be able, then suddenly there's a very short deadline. You need to throw in a couple of more lawyers on that case. And you need that capacity and you need the staff and that, they all need to be involved in the matter. So you have because of the strict time schedule.
Just one comment from the judge's perspective here is, as you just said, and I want to pick that up, you at least have the possibility to throw in more people quite quickly and maybe by hiring 5 new associates who do confidentiality requests. It's basically the judge rapporteur and finally also the panel sitting there. But at this time, someone is really a bit. It's difficult to streamline everything and break it down and in all these broad arguments, and sometimes it's a bit storytelling, which starts with Adam and Eve on CEP, which I litigated 1,000 times, and I know the ECJ case law, so you don't have to present it on 100 pages, full stop. Everyone would be happy if you just say you know ECJ and you know step 3. Of course, I know. You have to be very careful and prudent here, but I hope and I also have trust in you that after a reasonable period that you will see a bit more how we think, and then you also do not feel the necessity to advise your clients to bring all this in over and over again. Well, and I must say also as an advice, I may not give legal advice, but my advice is you really have to be careful to focus on the crucial points. If you tell a story on 200 pages and I start reading and your decisive page is on 178, I might have been a bit too tired to pick it up.
I'm fully with you. I just remember a saying on marketing, 50% of marketing is completely superfluous. Just tell me which half.
There's one final question there.
In another panel discussion, which I mentioned before, the patent attorney sitting on the panel said actually he expected more opposition at the EPO because of the UPC, because it's still cheaper. And what is your opinion on that?
I will just drop out because I need to catch a train, so I leave it to my co-panelists to answer that. Thank you very much to everybody.
Thank you.
Yeah, I mean, with seeing more oppositions, it's I'm not so sure about this assumption, because I mean, with the oppositions you are limited to the 9 months, of course. Yeah, so that's the first point. And I mean, maybe I would be interested to see statistics on cases where the opposition period is still open. So how parties behave there, and if they do file the opposition then in parallel with the revocation action or a counterclaim for revocation, or so on. And the other factor to see here is, of course, at the moment there is uncertainty whether you get different decisions and take 2 shots. And then the third thing is, I mean, we know the EPO oppositions to instances may take some years, and at the UPC, I mean, we complained a bit about the tough time schedules, but the UPC is very good with their timings. So if you want to get the decision fast, then it's the UPC is tempting. So it wouldn't necessarily be my estimation that there is more oppositions, but I'm very interested to see the statistics.
Any final question?
Just a quick one. Have you identified a decision on the long-arm jurisdiction of the UPC? I repeat for online persons. Have you identified a decision about the so-called long-arm jurisdiction on the UPC, or do you think we can expect it in the near future?
The jurisdiction covering the Article 71.234 of the Brussels regulation.
I can only tell that we Düsseldorf and Mannheim have parallel cases pending where such a question came up. And we but agreed with the parties also to wait what the ECJ will now say in its preliminary ruling to that effect.
Thank you.
Thank you. So I am a French lawyer, but I lived 4 years in Germany, and therefore time is important to me. It's exactly 5:30, which is the time when we were supposed to stop this panel. I would like to thank the panelists very much. They did an excellent job, and this was super interesting. So please join me in thanking them.